Mr. Pelser and Ms. Tsai appear with me for the applicants, collectively referred to as government.
May I please put my learned friends back to the seat? Goodman, Raga, and I appear to respond.
May I please put the learned friends, Ms. Steinberg, Mr.
May it please the Court, Justice Lewis and Justices, I appear together with my legal Julia and Ms. Lewis for the African Center for Justice and Peace Studies, being the first and second study in the Army Club.
May it please the Court, I appear for the Peace and Justice Initiative by the Center for Human Rights, which seek admission as amicus curiae.
Thank you. As I indicated in chambers, we'll hear the applicants first, that is government, then of course the Southern Africa Litigation Centre, Mr. Trengo, and then the Helen Suzman Foundation will have the opportunity to argue. They have been admitted as amici, or as an amicus, and then the other applicants for permission to be admitted as amici will be heard after that. We'll consider all the matters together and not adjourn to make any decisions either on whether we should grant leave to appeal or on whether we will admit the amici. With that, Mr. Gauntlet.
Thank you, Justice Lewis. If it pleases the Court, the way we would propose to deliver our oral argument is not to seek, even in an abbreviated way, to track through our heads of argument, which really stand, we would respectfully ask, as a written argument. We would think the Court would be best assisted if what we seek to do is to grapple more closely, now that we have them, the heads of argument for the other party, for SALC, and to deal to an extent with the submissions which have come in from the amici curiae in an endeavor to get to the hearts of the issues. What that would mean is we would wish to start firstly by seeking to identify what are the, as they are put, the main and subsidiary questions or issues raised by SALC. Secondly, to state our case as simply as we can. Thirdly, to examine the logic of the judgment of the full bench. Fourthly, to go to what we submit as the heart of the matter, which is the proper interpretation of Section 4.1 of the Immunities Act. Fifthly, to examine the attempt, particularly by SALC, to call in aid international customary law to argue through applying 232 and 233 of the Constitution for a different construction. Sixthly, we want to deal with their particular heart or core contention that the effect of Sections 4 and 10 of the what they call the ICC Act and we call the Implementation Act do not achieve what they contend for. Then deal with the reliance on the Genocide Convention and the Security Council resolution. Consider what we say is an alternative basis on which the application should succeed, namely that a ministerial notice was published which, properly construed, had the effect of giving the temporary immunity for which we contend at the time, and that notice was not challenged, notwithstanding a provocative statement in our answering affidavit at the time pointing that out and inviting challenge. And lastly, to deal with some multiple issues of costs, very briefly, we hope.
You haven't mentioned the fact that the full court found or held that it wouldn't appeal because the matter was moot.
Yes.
Al-Bashir had flown the nest.
Yes.
Stand it, some argument as to whether this order is appealable because it might be academic.
Now, I mean to include that in my first point, which is the omnibus point of what we understand to be SALC's main and subsidiary questions. And Justice Lewis, with respect, is entirely right that in the practice note and in the last paragraph of SALC's heads of argument, it is said that this court should dismiss the application for leave to appeal. Not a word, however, is advanced in support of that proposition in their heads of argument. We respectfully submit that it is an entirely unacceptable approach in this court. We are all required in our heads of argument, if we advance propositions or seek relief, to address them in our heads of argument so the court knows and so that the other parties know. Inexplicably, in this case, where the question of the refusal of leave to appeal bulked large, as the court knows, and unfortunately necessitated the, in old language, petition to this court, it's to us incomprehensible that that argument has not been addressed. And so I must briefly, if with the court's leave, punch at shadows. I shall seek to do so.
Very briefly, please, Mr. Gauntlet, because I don't think that it merits much time.
Thank you. Milady, what we have to say about it in the most practical and simple terms is this, that the court will appreciate that the effect of the declarator granted regarding the unconstitutional conduct of government and the order issued that the serving head of a state should be arrested stand without time limit. And in fact, as it is put up before you without any challenge, SALC, while simultaneously asserting before courts that the issue is moot, has, through the other side of the mouth, said that it intends to proceed with other proceedings, such as the criminal proceedings, presaged by the, to them, useful last paragraph of the full bench judgment, signaling that such a course might be open. That's the first point. The second point is that we would have thought that on the most rudimentary reasoning, the fact that an order is made, which was not made because it related to the personality of one particular serving head of state, but to a situation, namely that a warrant exists against him, as it has done in respect of, say, President Kenyatta of Kenya, and it may in the future do in relation to other serving heads of state, did not mean that this was a butterfly in the legal landscape. Meant that this is something with very serious implications. Thirdly, the court would know that through Section 4.2, which is a mirror of Section 4.1, the same reasoning would apply to potentially hundreds of officials of the United Nations, embassies, diplomatic officials, and the like. So very shortly, subject to the court's requirement, we would respectfully submit that what the court did below in holding that it was moot was indefensible, and that we say that the point, as we've said in our heads of argument, is not responsibly taken. If it was responsibly taken, it's something which should be vindicated, asserted through the heads of argument in a way that could be grappled with. The time of the court below was wasted. Getting to this court resulted in wasted time, and this court's time has been wasted by what we respectfully submit is simply not a reasonable proposition.
You said a moment ago that the declaratory order was unlimited as to time.
Yes.
But as I read the order, conveniently available at page 118, it spoke to the conduct of the government, if I may adopt your nomenclature,
Yes.
at the time. It didn't speak to any future occasion or anything of the sort. It simply said the conduct of the respondents, to the extent that they have failed, which is past tense, to take steps to arrest and detain President al-Bashir, is inconsistent with the Constitution.
Yes.
That's a statement of past matters. It's not a statement of future events.
No, I don't mean to assert that it's a statement of future events, other than that it would operate in a way supportive of the order which next follows, and which I assume your Lordship would accept, operates entirely in futuro.
Well, I'm not entirely sure that's so, because it speaks as to the date when the order was granted. But it ties in with another concern I have, Mr. Gauntlet. In the opposing affidavit delivered on behalf of the government by Ms. Sindani, paragraph 3, from pages 51 through to 59 of the papers, she set out in some detail the justification for the government not taking steps against President al-Bashir. And as I read that paragraph, the only justification advanced was the agreement.
I'm sorry, Justice Wallace, I've been distracted by some whispering behind me. Thank you. Sorry.
It's all right. Be distracted by the whispering in front of you, Mr.
Indeed.
Gauntlet.
Thank you.
As I read that paragraph, it says that the basis and the justification advanced by the government was we've concluded an agreement with the AU in regard to the conduct of the summit. That agreement affords President al-Bashir immunity from arrest, and that's been reinforced by the decision of the Cabinet, which is referred to in Dr. Labisi's affidavit, and the proclamation made by the Minister. And that was the only ground advanced for saying this is why we as the government have not caused President al-Bashir to be arrested. Is that a correct understanding of the approach adopted by your predecessor in the High Court?
What Justice Wallace leaves out of consideration are two things with respect. One is the realities which pertained, which is that the High Court judge presiding on the Sunday expected affidavits dealing with this issue to be prepared in a matter of hours. Well, they were prepared, and to the distress of the court, only filed the next day. They were prepared in circumstances where it was clear that what the court was operating urgently, and the answer was given urgently. If what Justice Wallace is suggesting, that there's a single legal argument encompassed in our argument which is not entertainable by virtue of that answering affidavit, we would respectfully say that that could not be correct.
Well, perhaps you could actually answer the question, Mr. Gauntlet. Was in fact the argument in the court below an argument based on the propositions I've put to you in paragraph 3 of Ms. Sindani's affidavit?
Substantially, as I understand it, Justice Wallace, but like you, I have no benefit other than what is in the judgment and in the papers.
Well, if one looks at what is in the judgment, that is the way in which the High Court articulated the issue before it. So that's what it said in its introduction at page 118 in paragraph 1. Directly posed, the question is whether a cabinet resolution coupled with a ministerial notice are capable of suspending this country's duty to arrest a head of state, against whom the ICC has issued arrest warrants for war crimes, crimes against humanity and genocide. And if you'd like me to cut to the chase, Mr. Gauntlet, what I'm concerned about is we now have a mountain of paper, an argument that is developed on the construction of the Implementation Act and the Diplomatic Immunities Act, on authorities which were not cited, were not before the court below, were not raised at all, and we are asked to entertain these arguments in an application for leave to appeal as a court of first instance, and doing so under some of the time constraints that you complain of in the court below, but I seem to recall from an earlier life of mine that doing things urgently is something that members of the bar are required to do regularly.
Yeah, I wasn't complaining, I was explaining, Justice Wallace. But Justice Wallace, to answer the point, what matters we respectfully submit is whether any of the propositions of law which we advance on appeal are precluded by the ambit of the answering affidavit. if, as a consequence of the fact that the matter was heard, and it happens at times, as the court well knows, the court will recall in emergency years, and Justice Wallace was a combatant in those trenches like Sinoli, if a court at first instance does hear a matter urgently in relation to banning of meetings or the like, and it is wrong in law, and part of the wrongness in law may be the inadequacy of the argument of the parties before it. On appeal, the issue will simply be, it's a pity that in fact there wasn't more argument on appeal, on first instance. It's a pity that the court didn't have more time, and it may be a pity that the court below didn't do a better job. The simple issue is whether I'm precluded.
Any new facts, Mr. Gauntlet, that we need to take into account in order to consider the argument that government now advances?
No.
So the only things that were not traversed by the court of first instance are principles of law.
Absolutely, Justice Lewis. That's exactly the focus of our argument. And reverting to the beginning of Justice Wallace's question, which went to the issue of mootness, we do not with respect accept that the terms of the either the declarator or the standing order for arrest are such that if the President of Sudan comes to the country next week for urgent medical attention or for an urgent visit relating to the situation in Darfur and peacemaking or any other consideration, we do not accept. And we would invite our learned friends to indicate, if they so construe, that the order is such that it means nothing and that the President could come and go without any consequence. We say it's not the way that either order reads, and we say also that when Justice Wallace raises for debate the question whether the declaratory order is purely historical, even if it were so, my clients came to this court and said, an order has been made that we behaved unconstitutionally in what we do. In terms of the relations between government and the courts, it's very important for us to clarify whether that is wrong, because for the reasons I've indicated, this is clearly not some weird and wonderful chance situation of the arrest of somebody who happens to be passing through Cape Town from Singapore to Rio de Janeiro with no possible anticipation whatsoever. What is clear, he's a serving state in Africa. He's the serving head of state of another member of the African Union. South Africa is engaged in the African Union, and as the gathering in Johannesburg pointed out, would from time to time, it may be expected, be the host for those meetings. So for both those reasons, we would respectfully submit that the mootness basis of the argument of the court below, or the finding of the court below, was unfortunate, not quite as unfortunate as its finding on the merits, where it was indicated, and it's accepted by counsel, that we should not trouble ourselves in dealing with prospects of success. We should deal only with merits, and we are then faced with a judgment which goes against us on both.
Yes, well, we don't have to deal with that. You have made your point at some length in your heads of argument.
May I then...
Sorry, just one final question, because my questions weren't directed at the issue of mootness. They were directed at the question of whether leave to appeal should be granted. Now, you've cited the points, the cases which say that if there's a discrete question of law of public interest, even if matters were moot, the court will hear it. But there's another string to that bow, isn't there? And that is whether it is in the interests of justice that leave should be granted. And that's been mightily developed by the Constitutional Court, which has frequently said that where interesting, difficult and important points of law arise, but are raised late or are raised for the first time on appeal, it is not in the interests of justice that the court should entertain them. And it then refuses leave to appeal, leaving them to be raised at a more appropriate time in the future. And so my questions were really directed at that issue, which I don't think you've addressed.
We respectfully submit that if it isn't moot, which I understood to be the first thrust of what was being put to me, if it is not, cannot reasonably be argued to be moot for the reasons I've given, Then the second issue which does arise is that in relation to which Justice Wallace wrote the important judgment in Mbiti Technologies by saying it's not game over, a court may still look at the issue for the reasons that he gives. The suggestion that in this case, because of the circumstances in which the application had to be heard, which was in circumstances of extreme urgency, that the questions of law now ex hypothesi what I argued before, permissibly argued before you, that those matters are matters which somehow should be put off for another day, we respectfully submit is wrong. This court in pre-constitutional years in cases like LTA construction versus CCAT engineering, the judgment of Justice Janssen, also I recall in LDC Development Bank versus Lipschitz, or Standard Bank versus Lipschitz,
UDC Bank,
dealt with the issue of when counsel gets up in the appeal and argues points of law which are completely new, as long as they're encompassed by the pleadings and the evidence, the court will say, well, we've got to deal with it. We're not assisted as it is below. So with great respect on any level, we would submit that there's no basis to consider that it's moot, and furthermore that even
the new issues of law that the appeal raises.
The new issues fall into what I've said is the long-established basis that this court would deal with them, as it deals very often with new issues of law raised on appeal, either because counsel were too dim or the judge was too busy below to deal with it. And if it's in the game, it's in the game. And we submit that this is such an instance. So now, with the court's leave, move on from the non-issue of mootness, though, to analyze what we're up against in terms of argument. We've said, first of all, SALC is silent on leave to appeal, and we say unacceptably so. There should have been an argument that could be grappled with. And secondly, you'll notice overall SALC does not come to grips anywhere. Does not come to grips anywhere with the distinction between immunity ratione personae and ratione materiae, and we'll deal with that later. Thirdly, a large part of SALC's argument pleaded was that constitutional law had, Freudian slip, that international customary law had developed to exclude reliance on personal immunity. It's had to row back incrementally on that in its heads of argument, and the high watermark of its heads of argument now is that Professor Dugard has it right when he says that international customary law is poised to move to a situation which would exclude personal immunity, but again, in his language, it's in a state of flux. Well,
isn't the state of flux caused not only by a developing attitude towards law in a global community, but also by the introduction of treaties, such as the Rome Statute, which changed the game in relation to immunities, when one is dealing with crimes such as genocide, torture.
What we're going to say is that it's all very well, but in a little article we intimated to Justice Lewis presiding, we're going to ask leave to hand up because it came to us late, by the premier professor or chair in public law at the University College of London. He says that a few swallows have not made a summer, and that the position is unequivocally so that if you ask the stark question, after, as Justice Lewis says, noting that there are trends in treaty obligations in that direction, is it? That's not the question that Professor Dugard and those who go with him allow to be asked, because they know what the answer is. Or when Professor Dugard does answer it, as we quote in our heads of argument, he gives the only possible answer, which is that we're not there yet. And so as a matter of statement of international customary law, if it does come into the debate and is considered, we're saying that the conclusion is exactly, even on SALC's approach, no more than a state of flux, no more than poised, which must mean not there yet.
How does this court, sitting as a court of a country,
yes,
not an international court,
yes,
how do we determine what is the content of international law on this topic? Do we derive it from, is there any hierarchy of courts and tribunals? Much of the material we've been given is academic writing from various sources.
Well, with respect, we would say that that's a position which goes back to Pan American Airlines in the 60s, Justice Rumpf asking and dealing with much the same question. And it's ultimately establishing, first of all, the pronouncements of the international courts, such as the ICJ, what it has to say. We also will look at what the ICC has to say about the ICC. And when you have a judge sitting in a pre-trial chamber late on a Saturday night before our case is to be heard, and he opines on whether or not South Africa is bound, South Africa has no operative immunity, he can't do that. It can only be done by a South African court. What he can certainly opine on is and some authority, sitting, as in that instance, one judge in what is a chamber court, but is the position of the ICC. But Justice Wallace's question goes to the heart of the difficulty in the matter, and that is that each domestic court would, in instances, have to pronounce on its understanding of what international law is. And I believe in the end it would be in the same way as each domestic court may, in certain circumstances, have to say what is current New York commercial law on a particular point. It would have to reach its conclusion, and in doing so, it would take into account hierarchy of pronouncements, etc., by the New York courts. But ultimately, this court reaches its goal.
Look at the domestic statutes.
I'm sorry?
Why wouldn't the court sitting on a Saturday night in chambers look at the domestic statutes?
Oh, you mean the ICC chamber court?
It's
Well, you see, we would suggest...
No, I'm referring to the court that dealt with the urgent application.
Oh, absolutely. But I'll tell you why.
It would look at the Implementation Act, as you call it, and it would look at the Immunities Act, and it would have regard to the Constitution, and without resort to bundles and bundles and bundles of academic treaties, it would be able to make a determination on what South Africa's obligations are.
And I would like to show you now, Justice Lewis and members of the court, that that's the fine point of the appeal, that where the court below with respect went wrong, it was beguiled, even in those compressed circumstances, beguiled by advocates and listened too long to them. It really came to the issue before it, where government was saying, I stand on one of two legs. And government, let me say, in those urgent circumstances, not saying it perfectly, but the points were there. The one is that Section 4 gives immunity to all, civil and criminal, absolute, for anything from genocide to parking offences, for anything from fraud to anything else, to a serving head of state. For as long as you are the serving head of state, your day will come. The same way as in many countries constitutionally there's been the problem, how do you deal with a Richard Nixon? And the answer given constitutionally often is you suffer him until his removal. You can't prosecute him in the meanwhile. And the presiding judge's question goes to the heart of the matter.
Yes, but the presiding judge, if his attention...
you, Justice Lewis, not that presiding judge.
See, well, any judge, having looked at Section 4, which the court, in the month that it had to give reasons, apparently didn't do particularly carefully, and would have looked at Section 5, and then would have looked at the provisions of the Rome Statute, and it would have said, what is the purpose of the Rome Statute but to change the law insofar as immunities of a head of state accused of international crimes? What would that be?
Yes. Well,
Is there any purpose in the Rome Statute if Section 4 of the Immunities Act is going to oust the provisions of this later legislation?
That I would like to show, because that is the nub of the matter, where you have two statutes effectively made both post-constitutionally, both within about 6 months of the dates of assent were about 6 months apart in 2002. And the question...
If I could just interrupt you there. The Immunities Act is hardly a new thing.
No.
It's had many predecessors.
Exactly. And if we are further correct that what the Immunities Act did was to say, effectively, we are going to domesticate, almost in words of one syllable, the very ancient, criticize if you like, but very ancient customary international law rule. And that is a serving head of state or his or her legate enjoy absolute immunity, because that's what the world requires. International relations require wicked people to be talked to. It happened in Vietnam. It happened at Lancaster House. It happened when President Mandela went to make peace between President Mobutu and the aspirant President Kabila. It happens and continues to happen in the flawed world in which we live.
Yes, and there's very good reason for it, as you point out. Nonetheless, the purpose of the Implementation Act, the preamble to the Act, Section 3 of the Act, and all its provisions change the game, do they not?
That is exactly where Justice Lewis and I'm sure you would be open to argument on the fact that it didn't change the game, because the only way it could change the game is in a way with which SALK and those who align themselves with SALK struggle. They can't say it was repealed. They don't say it was repealed by the later Act. They don't say...
It doesn't need to be repealed, because it stands insofar as the head of state is not accused of international crimes.
No, Justice Lewis, because what we say is that if you start with the proposition that you have a second act which comes, and what could be the purpose of the second act but to do why? Our learned friends do that in their argument, and it's understandable good advocacy to go for that, which is to say, let's look at why, i.e. the ICC Act, Implementation Act. Let's look at that. And let's also then go, and that is with decreasing confidence, into customary international law itself. But the effect of the statutory provisions in the Second Act, more particularly 10.9 dealing with surrenders, read with 4 in the ICC Act, that is to say that heads of state in a domestic court will not be able to invoke immunity. We say, if you start the other way around, which is to start with the first act, if we are wrong, and it does not, as a matter of interpretation, say a serving head of state has immunity, then we have no other place to go other than the Section 5 notice. That's why we have the 2 legs to the argument. But if...
It's very much as narrow as that, isn't it?
It does, absolutely. For us it is. And Justice Ponel respect is correct. And on section, it then becomes this. If one reasons in the normal way lawyers do, sequentially and chronologically, to say, well, there's a reliance placed on section 4 of the Immunities Act, which is adopted then. Let's just start there. What does that as a statutory provision mean? If you come to an answer, and that answer you cannot come to by saying, no, but quickly look at the later act. That will tell you what that act meant. Because what it means is what it meant when it came into operation, 6 months before the other. And then the question is, does the later act repeal it? And this is critical because Justice Lewis put to me a moment ago another way, or perhaps we have, but this is where our learned friends get into difficulty. Because when one starts to use words which are popular only in certain card games, or more latterly, unfortunately, in American politics like Trump, you have to ask yourself, what does it mean to a lawyer? You can understand it when you're talking about a hierarchy of statutes, then we all talk in the shorthand that the Act trumps the regulation of the Constitution.
Let's not talk about trumping, because I don't understand card games. But let's look at Section 4 of the Immunities Act and Section 4 of the Implementation Act, and read them side by side. And the one says, a head of state is immune from the criminal and civil jurisdiction of the courts of the Republic and enjoys such immunities as, and it lists a whole lot. And the other, Section 4, in the chapter on the jurisdiction of South African courts and the institution of prosecutions in South African courts in respect of crimes, says, despite anything to the contrary in any other law of the Republic, any person who commits a crime is guilty of an offence and is liable on conviction to a fine or imprisonment, and so on, is neither, despite any other law to the contrary, this is subsection 2, including customary and conventional international law, the fact that a person is or was a head of state or government, a member of government, is neither, and this is B1, offence to a crime, nor to a ground for any possible reduction of sentence. Now, forgetting about what is actually before the court, and that is the question of arrest, not prosecution in a South African court. How do you read the two sections 4 together and say that the Section 4 of the Immunities Act is not in any way affected? And I'm not suggesting for a moment that it is repealed, because obviously it would continue to apply to a head of state who is not accused of international crimes.
But then, Justice Lewis, we would submit clear to what we're doing. Because what Justice Lewis is positing to me is that we put the two acts side by side to construe them. I'm saying that the first thing to do is to establish a meaning which is to be given to the first act at the time it's enacted. That meaning, as a matter of interpretation, can't change because there's a later act.
No, the meaning of the Immunities Act doesn't change at all. What the Rome Statute does, as I understand it, is say heads of state who are accused of international crimes do not have the benefit of Section 4 of the Immunities Act.
No, it doesn't do that. Because if it wanted to do that, it could have said that so easily. What it is doing is dealing with a different topic. And the topic is saying this, that a head of state, like any other, and any army officer or etc., elected representative, if that person faces trial in a South African court, as it may do under this act, for an act committed in Rwanda or somewhere else, then in that trial, it cannot say my defense is I was the head of state and I have immunity. And likewise, that person cannot say that you have to give me a lesser sentence because my finger wasn't on the actual machine gun, I was higher up in the hierarchy. It is contemplating a situation in which you can have a person, and that's why the language is or was a head of state. So take President Bashir. President Bashir, at a future stage, would lose his Section 4 of the Immunities Act, immunity in South Africa. He would then face trial, arguably, conceptually, in South Africa. In those circumstances, at the end of his trial, because he couldn't invoke to keep out of the trial the Section 4 of the Immunities Act immunity, or secondly, I forgot to mention, it's been waived. Sudan has said, well, actually...
That's another argument.
No, but it's important. You can't pigeonhole them, Justice Lewis. It's important at this stage to recognize the difference between the two Section 4s is the first Section 4 is saying, as a matter of interpretation, an unchanging meaning at the time and now, that if you are a serving head of state, no matter what turpitude you've done civilly or criminally, you enjoy immunity. Section 4 of the ICC Act is saying that despite anything in any other law, a person who is or was a head of state and is on trial.
The is bit is what is important. You've started your argument with now the person is no longer a head of state. I'm concerned with is.
And that is why, with respect, when I gave the answer to the is point, and Justice Lewis sought to push it aside by saying waiver is a different point, it's an actual point here. Because what could happen is that Sudan could waive that immunity. And if Sudan waives that immunity, then he is still a president. It's very conceptually difficult, practically difficult to see that it may happen. But that is the purpose of it, is to deal with the fact that if the trial takes place, then when you reach the end, there is to be, and that's the important thrust of the ICC Act, there is to be no distinction between sovereigns and foot soldiers. If you were involved in one of the listed crimes, then when it comes to the question of whether or not you committed it and the sentence, you are treated absolutely equally.
In other words, what you say Section 4 does in the Implementation Act is replicate in respect of criminal charges in South Africa, which our courts are given jurisdiction over, the provisions of Article 27 of the Rome Statute, which says exactly the same thing and which dates back to the Nuremberg trials. It's no good coming to this tribunal once you're before it and being properly charged before it and saying, but I was a head of state. That's not a defence, it doesn't mitigate your sentence. And you say that leaves Section 4 of the Immunities Act untouched. But then can we look at Section 4 of the Immunities Act?
Yes, well, that's what I've been trying to do for a long time, so I would very much like to.
Please finish what you have to say in response to Justice Lewis. I want to come back to the Immunities Act.
With respect, Justice Wallace, since he asked me if that's a correct statement of what we say, it is absolutely that. And we say that the purpose of the ICC Act is to bring down into domestic law the obligation created by South Africa for itself at international law level. And part of that, through the Rome Treaty, is that kings and foot soldiers, when it comes to the crime, they must do the time. That they are not to be able to invoke at the end of the trial a defense or a sentence. But there are the two instances which I've given, namely the situation where the person ceases to be a head of state, and it's recognized by was, so falls within, and the second one being an instance where there's been a waiver. So that is the gap which opens up between them. So then we say, and Justice Wallace is right to put it that way, we then say, and it's the thing we try to say first, let's first look at Section 4, let's see what it does. And if it was changed by what happens, and we submit not. So I go to Section 4 of the Immunities Act, and it says, the head of state is immune from the civil and criminal jurisdiction. Now, then our learned friends say we rely on 4.1a. We don't rely on 4.1a.
Before we can get to 4.1a,
yes.
Immune from the criminal and civil jurisdiction of the courts of the Republic. It's not referring to the International Criminal Court. And the court of first instance was not asked to prosecute, it was asked merely to stop the departure of al-Bashir and to order his arrest.
The order sought was an order we trust which was sought within jurisdiction of the High Court, because if it was an order not being sought within the jurisdiction of the High Court in Pretoria, its short answer would have been, we can't deal with this.
No, that isn't the point, Mr. Gauntlet. Surely the point is this. The immunity is given from the criminal and civil jurisdiction of South African courts, where in the process, let's forget that there was a fight where your clients, the government, were alleged not to have done what they should have done. Let's assume they'd done what Mr. Trengove's clients say they should have done. Assume they had arrested him. The only engagement with a South African court would have been under Section 10.5 of the Implementation Act. which would have involved an inquiry not sitting in the exercise of its criminal and civil jurisdiction, but in the exercise of its special jurisdiction under the Implementation Act, to say, is this the right person? Is there a warrant? And should they be surrendered to the ICC? So when we start, as you ask us to start, and you may well be right about that, with is immune from the criminal and civil jurisdiction, where in what they sought to force the government to do was President al-Bashir being submitted to the criminal and civil jurisdiction of our courts.
We thought the answer was easy, Justice Wallace.
Well, I didn't find it easy, so I'd be grateful for your help.
We thought the answer was clear in that the language, firstly, of 4, talking about the criminal and civil jurisdiction of the courts of South Africa, means that whenever the courts of South Africa have jurisdiction in a matter, there will be such immunity. Immunity, 6 months, jurisdiction of the South African courts was extended 6 months later through the operation of the ICC Act to enable people who were subject to arrest at the instance of an ICC warrant to be drawn into the jurisdiction of the South African court. And that you would see starting in section 8.2 of the ICC Act, as it's called, because it's got to go, the request is received, it goes to a magistrate who must endorse it, and so it goes on through section 9 with procedures for how the warrants, etc. work, and then into section 10.
No, section 9 deals with provisional warrants, which have nothing to do with this case at all. That's urgent warrants. This is a section 8 case,
Yes, I'm not dealing
followed
with
by
this case,
section
Justice
10.
Wallace. I'm dealing with the issue of principle, and you asked me.
Can we deal with the question of principle on this basis? And I appreciate it's hypothetical. If instead of saying that the arrest warrant should be forwarded to a magistrate, it had been endorsed by the central authority, who's the Director General, and after it had been served, presumably by some policeman or other, instead of the matter going before a magistrate under section 10, there's no requirement of the Rome Statute that it should. It had simply been dealt with administratively within the departments concerned, Home Affairs, Police, or whoever. There would be no question of a breach of section 4 of the Immunities Act, would there? And that's why I put to you the question about the civil and criminal jurisdiction of the court. If this process was purely within the administration and the Implementation Act had not said magistrate, surely we couldn't be having this argument.
No, but that's because, Justice Wallace, I hadn't finished the submission, which is, it starts, I said, with 8. 9 applies, as its heading tells us all, to provisional warrants. And then 10 says what follows. And that is a proceeding before a competent court after arrest for purposes of surrender. So you end up in a South African court.
I just want to put this in the perspective that we have 2 international arrest warrants against President al-Bashir. They were issued against the background of a UN Security Council resolution asking states to cooperate. Now, I think in the specter of a constitutional dispensation, where under section 232 and 233 we have to honor our international law obligations, I find it difficult to follow how you, in answering my brother Wallace's question about civil and criminal jurisdiction of South African courts, well, surely we are dealing here with a request to a state party to assist and to cooperate to arrest President al-Bashir to eventually stand trial before the ICC. Now, I don't understand how you restrict yourself to section 4.1 of the Immunities Act without having regard to our international law obligations under the Rome Statute and under the Implementation Act.
And under the Constitution.
Yes. Well, may I deal with that? But I need first, and I'm not evading Justice Majid, I need first to deal with 4, and then I need to come to the effects later, such as the reliance where it fits.
4 of the Immunities Act.
Of the Immunities Act. I need to consider the effect on that of section 4 of the ICC Act read with provisions, such other provisions as are called in aid, such as 10.9 and 10.5. I need also to say, is anything changed in that answer by, as Justice Majid puts to me, there was a UN Security Council resolution, to which my short answer is going to be that UN Security Council resolution, and we rather thought that this was accepted in this court, itself created no obligation on South Africa. What it was is it created an obligation, to the extent it could, on participants in the Darfur struggle, and then ended with a call, I think the word is, but to other states to assist.
Except that resolution, we know that the ICC normally would only have jurisdiction over cases where the crime is committed in a particular state or the person is a resident in that state. But the resolution creates jurisdiction for the ICC as an exception. And I mean, that's important because we are dealing here with a request to arrest to stand trial before the ICC.
Now, that is with respect correct. The United Nations Security Council, 3 permanent members of which are fastidious non-signatories themselves to the Rome Statute, adopted such a resolution creating jurisdiction for the ICC, effectively then to bring what it could to bear in relation to President al-Bashir. As Justice Majid points out, there were 2 warrants which were issued. The interesting thing about this case, and we don't want to get involved in the intestinal detail of 8, 9, or 10 particularly, but what happened in this case, as you know, there was an approach to Justice Fabricius sitting as a High Court judge saying, please use 41K of the Criminal Procedure Act, arrest that man. So what happened was effectively an interesting bypass. It's a point we note in one of our grounds of appeal, but there was a bypass of the actual procedure under the Act. And what I'm tracking at the moment, and I must get back to the point, which is that where it culminates in, if you are so arrested, it culminates in proceedings before a South African court. And our argument is very simple, that when Section 4.1 of the Immunities Act creates in its terms, domesticates, recognizes, puts beyond debate the old rule of customary international law, which is absolute immunity for the duration of your office when you are a head of state, that what that immunity encompasses is that you don't lose your liberty. You don't get arrested. You do not get taken before a South African court.
Inquiry. Why is that the exercise of the criminal or civil jurisdiction of our courts as opposed to an inquiry in terms of the Insolvency Act, which takes place before a magistrate, an inquiry under the Companies Act, or all the manifest things? Magistrates have for many, many years in this country done things which have nothing to do with the judicial function. That's what the Constitutional Court dealt with in personal injuries and recently dealt with in the Performing Animals Act case.
There is one question for us all then, Justice Wallace. On the 15th of June last year, when Justice Fabricius convened the Pretoria High Court and made orders, and there were the subsequent orders, temporary orders made, and then the final order, whether what was being exercised was civil or criminal jurisdiction of a South African court.
Jurisdiction of al-Bashir?
Not yet, no, but it was certainly a jurisdiction which was being exercised, and if it wasn't criminal, it was civil. And that doesn't get one then anywhere other than saying it's still within 4.1. But with respect, there has to be a reality check, because the reality check we submit is this. What is the scheme and the intention of saying in Section 4.1 of the Immunities Act? Very simply, anyone, as long as they're head of a state, that person must be untouchable in our country for that period, civilly or criminally. That's the purpose of interpretation.
Indicated earlier in relation to Section 4 of the Implementation Act, is that the head of state loses immunity when he or she ceases to be head of state, or when he or she has waived immunity. And your argument, of course, is that there is no waiver despite the UN or the Security Council resolution, and despite the fact that Sudan signed on to the Genocide Convention.
Yes, absolutely. Which is why I will deal with those in a moment, because they're the important aspects also raised by Justice Majid. But staying...
But it gives a very, very limited meaning to the Implementation Act. It renders it virtually purposeless.
No, because if we're talking about interpreting it purposively, we know, because it says so in the short title, the long title, and frequently afterwards in its objects and everything else, what the Implementation Act wanted to do was bring down into domestic law what the Statute of Rome was creating by South Africa's accession to it on an international law level. That treaty itself in Article 108 acknowledged that existent immunities would be unaffected. It was not saying that
in relation to this category of offences.
In relation to anything. And this is Justice Ponnen raises a terribly important issue, because there are two ways of interpreting what the Treaty of Rome was doing and then the Implementation Act. And that is whether it is saying, first of all, at the treaty level, that we are not interested in what other immunities claims there may be in Bulgaria or anywhere else in joining. When you join us, there will be, when you implement, as you are going to be required to do as a member, this act, it has the effect of destroying those immunities. And we respectfully submit that it didn't do that. The critical thing then is this: it goes back to the fundamental question. If you put the two provisions side by side, having performed the exercise, firstly, of interpreting simply and purposively the first provision, this first section 4 of the Immunities Act, what it does is to say, in terms against which the other participants in this court jib, they say that can't be so. They go to international customary law, they say that it's poised to change it. It's on the edge, etc. That means that international customary law, we ask you to find, at the time that Section 4 of the Immunities Act was implemented, was four square on that position, that it said, never mind the crime. There are important reasons why the wicked must be allowed to come and be spoken to, etc., etc. Then the question is, as a matter of interpretation, given the absence of any repeal, etc., does the wording of Section 4, by referring to an is or was situation, and by contemplating then the position which arises during the conduct of any trial in South Africa as a defense to a crime or reduction of sentence, when it imposes what I've called this equality, to say if you enter that, you get no get out of jail card, you get no defense, you get no special treatment on punishment. But it is not taking away what had been put into law just months before, and what we say was the lex specialis on immunities in the widest terms. And we say that far clearer language would be required to do that. And if you try to go to international law, to call in aid for the virtues, the purposes, as Justice Lewis has put to me, of implying Section 232, 233 of the Constitution, the question then becomes, show us that international law is where you say it is. And at that stage that...
Mr. Gauntlet, simply by looking at the Rome Statute and the Implementation Act, which gives effect to it.
Well, we submit that it doesn't do that, that Section 4, to which we've been devoting much attention, doesn't have that effect, that proceedings are set in train within the jurisdiction of a South African court, as is contemplated by Section 10. There may be special proceedings, but if they have to be put under something cognated civil jurisdiction or hybrid civil or criminal, it doesn't matter, because the original Section 4 is trying to couch it as widely as possible. So we say that Section 10 does that, and we say that when Section 10.9 says the fact that the person to be surrendered is a person contemplated in 4.2 A or B does not constitute a ground for refusing to issue an order contemplated in sub 5, it is dealing with again the situation which may be that the person has ceased to be a head of state, it may be that there's been a waiver, in which case Section 4 gives that person no protection, and that person can't at the end of the process say, don't surrender me, I just want to remind you I'm a head of state.
So you would say 10.9 is subject to the same interpretation as 4 of the Implementation Act, and where it says that the fact that the person to be surrendered is a person contemplated in Section 4, that refers to somebody who was a head of state or who is still a head of state and has waived immunity.
Yes,
so one would have to read in an enormous amount in order to adopt your interpretation.
No, I wouldn't, because the was is there. So that's the first thing. And as regards the is, the point is that if another statute has established in the simplest and widest terms that a person has immunity, then the person has immunity. And that we would say conversely that what this court would be doing would be in very strange circumstances saying that, I know that presuming the lawgiver knows the law is always a bold statement, but here we have a 6-month gap, have a situation where the lawgiver, in making the new Section 4, as it were, the new Section 10, and uses that careful language that it's only related to the defense of the crime, to a crime, to sentence, and lastly, that on the issue of surrender, if you reach that stage, you can't raise your hand and say, I am such a person. But being such a person is a person who is not protected by Section 4.
Your submission. 2 questions. The first one is this. It would have been open under the Implementation Act to the National Director of Public Prosecutions to charge President al-Bashir when he was in this country under Section 4.3c. Open in theory. Do you say that the effect of the Diplomatic Immunities Act, Section 4, is that even though he could have produced a charge sheet and wanted to prosecute him, he could not have had him arrested and brought before the court? Is that your submission?
Absolutely.
So even though he could have theoretically prosecuted him in South Africa, in practical terms he couldn't have brought him before the court. And you say that applies equally to the ICC. Because Section 4 is dealing with the jurisdiction of South African courts.
Yes.
So if he decided under 4.3c,
yes,
a man is present in the Republic,
yes,
I want to prosecute.
Yes.
So I issue the charge sheet and I say to the police, go and arrest him and bring him before the High Court, wherever. Your answer to that is they couldn't arrest him because of Section 4 of the Immunities Act.
Absolutely, because it would be, if I might...
I just want to know that is your submission.
But I just need to explain the submission, Justice Wallace. Yes. The reason for the submission is that if the whole exercise presupposes that there will be some form of presentable warrant, it presupposes that there may be a prosecuting authority, to use Professor Dugard's phrase, poised to act on it or seeks to act on it. What Section 4 simply does is to say, Mr. AG, Mr. Prosecutor General, you cannot have such a person arrested and you cannot proceed unless one of the two things happen. He can draw up his indictment.
But
He can have it. He can have it ready. And
nothing he can do with it.
no, not immediately. No, but that's the critical thing, Justice Lewis, because there seems to be this way of looking at the case, which is that a temporary immunity creates an encompassing impunity. It's not right. It's just a hard decision which was being made, which is to say, as I've said before, that we need to have a situation where, to quote not a jurisprudent but Professor Mr. David Cameron, no ifs, no buts, there's no way that somebody visiting this country who is a head of state can be arrested and pursued while the person has that status. And nothing, and that then is the argument, nothing.
Yes.
In the Rome Treaty...
That is why Mr. David Cameron hasn't signed on to the Rome Statute,
Yes,
whereas South Africa has.
Yes.
And the second question, going back to the Immunities Act, when the matter is referred to a magistrate under Section 10, is the magistrate exercising criminal jurisdiction, civil jurisdiction, or merely performing a function pursuant to the obligation to bring about the surrender of a person to the ICC? Is it criminal? Is it civil?
I would say, Justice Wallace, that the short answer doesn't matter, because, if I might finish, because unless it is equated to an insolvency inquiry, something which is then thought to be al fresco, outside the ambit of the jurisdiction of the court, what's going on is that South Africa has entered into this relationship which says, in certain circumstances, certain people on the principle of complementarity either must be prosecuted by us or by you. And this is a preliminary step to achieving the prosecution by the ICC. So that magistrate, by statute, is exercising a jurisdiction which is going to culminate in criminal proceedings. And that cannot fastidiously be semantically disaggregated, we say, from what is intended by Section 4.
Why is it any different from the position had the various steps outlined in Section 10 been delegated to appropriate officials and not to a magistrate?
I'm sorry, I give you
If the various steps under Section 10 had been delegated not to a magistrate, but to an appropriate official at a high level of government, why would that have been within either the criminal or the civil jurisdiction of our courts?
It wouldn't be. Justice Wallace put that to me as a hypothetical before, but what I have before me is the text of the Implementation Act, which says accurately in the marginal note, the heading to Section 10, proceedings before competent court after arrest for purposes of surrender. So it's not before an official. The court system is used. The Act has created a jurisdiction for the magistrate. The magistrate is not wearing a safari suit and sitting outside. He's in court dealing with a matter, or in chambers dealing with a matter. It's part of the jurisdiction of the court. Those are our submissions. Yes, and just, you will note in 10.1, you've got to bring that person before a magistrate in whose area of jurisdiction? What jurisdiction? Civil, criminal, it's there. So we respectfully then submit that where we are in terms of argument, as Justice Lewis would want to know from me, is that we submit that if you start, as Salk suggests, not with the first statute, but start with a treaty, start with an assertion about customary law, international customary law, which has been diluted, go back to the earlier statute, then what you effectively are seeking to do is, in this much abused term, almost read down, certainly read very restrictively the ambit of what Section 4 of the Implementation Act is saying. And we say, giving it the interpretation which I've been through as regards the advent of Section 4 of the Implementation Act, that there is nothing which can be said to repeal it, and to say that it negates it or trumps it with respect is to evade the central point. Was immunity given in the first section for, in the terms which we say it was? If it wasn't, is the wording to which Justice Lewis drew attention, namely a defense to a crime, won't be a defense to a crime, won't help you on punishment, does that mean that you have no immunity of passing into the jurisdiction of the court? And we say, no, that's been spoken for. The one is dealing with the initial stage, the other one is if you're unlucky enough or to have passed into the jurisdiction of the court because one of the two factors coming into play, then the circumstances change. Now, may I then deal with the residual aspects which arise? This is that if it's not trumped or negated by the ICC Act, then the suggestion in our learned friends' heads of argument at paragraph 58 no, that's not mine. The Genocide Convention. Sorry, I wanted to go to, I've got a wrong note.
I'm going to deal with the fact that Sudan and its president are bound by virtue of the Security Council resolution.
Yes, I am. Yes, let me deal with that.
Is that the point that you are going to?
Well, I'm going to deal with both. And the point about the Security Council resolution is addressed by our learned friends in paragraphs 51 and 52 of their heads of argument with respect in confused terms, because the submission made in the last sentence of paragraph 61 is that the effect of the Security Council resolution was to strip Sudan of any privilege, I mean immunity, that might otherwise have protected President al-Bashir from arrest and surrender to the ICC. First of all, it goes back to Justice Wallace's question. Whether or not the Security Council resolution had that effect is for this court in coming to its answer. The fact that the one judge in the what's called the South Africa ICC pretrial interlocutory case thought it had does not answer the question dispositively for this court. This court will decide whether it does. And in that regard, we again have a domestic statute. And this domestic statute was certainly not before the, clearly from his little, very short ruling, before the ICC judge in the Chamber Court. But we have, in our Immunities Act, very explicit provisions regarding how a waiver is to be effected. It deals with the United Nations, but it makes no provision for this sort of constructive waiver on which our learned friends rely. That the Security Council in saying, Sudan, you and your president have been wicked, there's going to be a case that there is the referral of the case and instructing the involved parties to cooperate. That constitutes a waiver such as meets our legal requirements. Our ones are very clear. It's quite clear that, first of all, there's no provision for the United Nations to have this sort of intervening supernumerary, what I call constructive waiver. That it somehow has the power to waive for Sudan.
You wouldn't suggest that the Security Council didn't have the power to issue that resolution?
No.
And you wouldn't suggest that it's not binding on Sudan? Your argument is simply that it can't be interpreted as the president giving up his immunity.
And our law, you can call it parochial, you can call it prudent or careful, but if you look at section 8.3, a waiver must always be express and in writing. And the notion there was clearly, if you read back into the section, that the sending state, the UN, each one in relation to its respective people may waive an immunity. And it, as I said, makes no provision for this remarkable way in which the Security Council found itself able to be very pious about the Sudan and pack it off to the International Criminal Court when, as I've said, several members are careful to keep away themselves. We say that that is an end to that. May I just say one thing I should have mentioned?
It's not a waiver
No.
in a strict sense, but the Security Council resolution must have some effect, and as
Yeah.
I understand it, and please correct me if I'm wrong on this, as I understand it, its effect is to make Sudan a
Yes.
party to the Rome
Yes,
Statute.
yes.
And if that is so, then Sudan agrees that a head of state who is accused of committing crimes as defined in that statute has no immunity.
No, we had the difficulty in the last proposition, Justice Lewis. It was a forceful and might be justified, it's not for any of us to say, but it's a forceful act by the Security Council to say, Sudan, you're not a signatory, but you are going to be inside the ICC's jurisdiction. We exercise a power which packs you off there. What the problem with the resolution is this: it does not address, first of all, what we say is clear from customary international law, that the sitting head of state would have immunity, and so therefore it's not expressed for the purposes of our statute. But secondly, our statute does not contemplate this form of constructive waiver. So whereas the resolution may be validly adopted, may have the effect of validly packing Sudan off to the United Nations, South Africa is left with its legislation, which is not attacked for any incongruity of the Constitution or anything else, which says, you know, when we have a waiver, it's got to be done this way. And we say that no amount of agility in relation to looking at the words what the UN did complies with these requirements. That's the argument in that regard.
Yes.
And as regards...
This might be an appropriate time at which
Thank
to
you.
take the tea adjournment. May I remind you, Mr. Goulted, that you needed but an hour.
Yes.
You will be afforded 15 minutes to conclude your argument when
Thank
we
you.
resume. Court adjourns.
Anyway, you've got the wind. I mean, not against you. judgment, 2014, and it holds in particularly precise terms that its active immunities, and it had an active immunities, covered anything which was conceivable in terms of the most egregious torture and the like. It was a civil proceeding, in fact, brought against the government of Iran and the Ayatollah Khomeini. And we commend to you the one flag passage in that judgment, if we might just hand it up to you without further comment. Oh, I'm sorry, the name of the case is Kazemi, yes, K-A-Z-E-M-I, estate of the late Zara Kazemi, versus Islamic Republic of Iran, Ayatollah Ali Khamenei, and its references 2014 SCC 62. It is a court not given to writing briefly, but the passage we refer to is a very short one. We say the point is whether it's civil or criminal jurisdiction, there is a Supreme Court that says it's entirely consistent with what has to be done to say that for the reasons we've argued at length, immunity must be held to be encompassing immunity, unaffected by any other consideration. May I also hand up that threatened article, very short in this instance, by Professor O'Keefe of the Public International Law at University College London, where in vigorous terms he refers to the attempts to suggest that international law is poised to do anything significant in this regard. No, he is a true internationalist, Justice Lewis. He writes about international law, and very briefly and usefully, I believe, to members of the court, would give you a very succinct update on the position. Professor Dugard was understated, or perhaps optimistic again, when he suggested it was poised in any direction, or the direction that he indicates. Justice Lewis, then may I deal briefly with what is the second leg of the case, the Section 5 aspect, the ministerial notice. In that regard, the Genocide Convention gives rise to the same, well, we've addressed it in our heads of argument, but it's the same position we respectfully submit, that you have the Immunities Act, which legislates for the field, and the Genocide Convention, Sudan's accession to it, does not have any consequence as regards the privilege which accrues to its sitting head of state for the requirements which I've already addressed of our own act. Not express, not in writing, not a waiver.
Well, I ask that because it seems to me that the case that you cite, Regina versus Bowes Street Magistrate, the speech by Lord Phillips seems to indicate that in the case of the Genocide Convention, it amounts to a waiver. And specifically at 189, they refer to it, I think one of the amicus curiae referred to it.
That is, with respect, not our understanding, but might I look at that, Justice Majid, if necessary, pick it up?
It's at 189, and it's the portion that starts with where states by convention agree that their national court shall have jurisdiction and so on. And then it says that the Genocide Convention removes an immunity by express agreement or waiver.
Yes, may I just give one short answer to that and come back to it if it's necessary? Throughout, SALC fails to distinguish between immunity ratione materiae and ratione personae.
Yeah.
Lord Phillips is dealing with ratione materiae in that judgment.
Except that in this passage, and that's why I want you to have a look at it, he specifically refers to ratione personae.
Well, thank you, then I will look at it again. But yes, there we are. There we are. May I deal with Section 5? And say that the point is simply that the notice incorporates, which is at page 42 of the record, and also at pages 101 to 2, incorporates by reference, as you know, what appears at page 92 in relation to Section C, representatives of member states. And it includes specifically immunity from personal arrest or detention. And that in item 6 on page 94, the expression representatives shall be deemed to include all delegates, deputy delegates, etc. The President of Sudan was a delegate of Sudan. The attempt to construe the ministerial notice as a matter of interpretation as according an immunity only to African Union representatives in the sense of staff, etc., is not right by virtue of that incorporation by reference, and it would be improbable, implausible, if one considers what clearly was being intended. So we respectfully submit that as a matter of interpretation, it has that effect, and after that, there is no word from the other side, if we are correct on that they have a capacity to brush it aside in light of Odekral and Kurland. So for those reasons, we submit that we should succeed on that separate basis.
As the ground of immunity, do you, Mr. Gortley? You simply say that because the proclamation hadn't been set aside, it stood.
Absolutely, sir.
Are you suggesting that on its terms, that proclamation, read with the agreement, conferred immunity on President al-Bashir?
It's just what I've argued, Justice Wallace. The argument is...
Are you serious? Where do you find that?
I find it in the notice, and I'm sorry to repeat.
The notice does refer to delegates.
It
Yes,
refers to delegates.
yes.
It doesn't refer to heads of state.
Well, then let me retrace my footsteps. If one...
The entire agreement with regards to this notice
Yes,
is designed to facilitate the organisation of the African Union's conference,
Yes.
is it not?
absolutely.
At South Africa's expense.
Exactly.
Yes.
And to that end, requiring the presence at the summit of the heads of state. And what you find in paragraph 1 is the reference to delegates and other representatives. The word delegates we underline, because what happens is our learned friend suggests that that should be treated without reference to the almost definition section which follows 3 lines later, sections C and D, articles 5 and 6. And if you go to delegates and dealing with the immunities at the pages which we referenced in the record, which is 92, including specifically representatives of the member states, coupled with the definition then in item 6. We say,
Delegate to the assembly, as opposed to attending by right, by virtue of Sudan's membership of the AU as its head of state. Where does it say he's a delegate? Within the meaning of that expression, as it is used in this document.
the answering affidavit at page 51 onwards invokes the host agreement.
Yes, well, the government has relied entirely on this
Yes.
notice and the agreement,
Yes.
and has not dealt, as you have indicated, with Section 4, which you would think would be the primary argument.
Yes.
But it doesn't anywhere state that a head of state is covered by this particular agreement or by the government notice that followed.
In its affidavit, Justice Wallace, I don't see that. But what I do see...
Nor did I.
No. But then it's a simple approach. Either the court holds that in the circumstances I've described, that where a reliance on the notice and the agreement is placed, I'm getting my prepositions are going awry, placed upon in the answering affidavit, the matter is argued before the High Court on the basis that it covers the President to such an extent that the High Court rather loses its way and forgets about Section 4 and deals with Section 5. That on some fastidious principle applicable to this kind of urgent litigation, I am disabled from contending on appeal that, as a point of law, on these documents, the President of Sudan is encompassed as a delegate. And we submit that the court would not do that. If the court holds, by virtue of the affidavit produced and filed on a Sunday afternoon or early Monday morning, that because there's not a sentence which says the President of the Sudan is a delegate, when that was the issue, clearly asserted, argued, and covered by the documents we put up.
Yes, but it's not just the answering affidavit that's lacking, it's the agreement itself and the notice.
Oh, no, well, that's a different point, and we say that either I'm right or wrong, that the notice has an umbilical cord, quite express, going into what it references. And if you go to what it references, it makes it quite clear that when it's incorporating it by reference in the notice, what Justice Lewis ultimately, with respect, by paraphrase, is putting to me, would it be a different case if it said heads of state in the notice? I'm saying no, if I'm correct, that the notice refers to a document which encompasses heads of state by reference to the delegate point.
Mr. Bloemfontein, I don't want to repeat myself, but again, one has to look at the purpose of the agreement and the ensuing notice, and that was to facilitate the hosting of the conference.
Yes,
not
absolutely.
to give immunity to people charged with international crimes.
Well, we would respectfully submit that the purpose of the provision was not to protect, and I mean them no disrespect, but subordinate lesser officials, OAU functionaries, who are least likely, as it were, to be in need of any such protection. But I'm either right or wrong, that there is an umbilical cord, it is an incorporation by reference, and the wording includes delegates. Delegates of a country would be the Minister of Foreign Affairs or whoever, and in instances where it's the head of state, it's the head of state.
Can you tell us what is the document under which sessions of the Assembly of the AU are held? Because amidst all this massive paper, I don't think anybody's bothered to give it to us.
Perhaps, Justice Wallace, because all parties were agreed it was of no relevance.
Well, maybe they're wrong.
Yeah, indeed, then that would be a loss of jurisprudence. So we respectfully then submit on either leg there is an immunity. I have argued that the recourse to the Security Council resolution does not create a waiver such as acknowledged by our law, nor does Sudan's position as a result of being a signatory to the genocide memorandum. I will revert to Justice Majid on his specific question, but we do stand full square by the proposition that all the law that we have seen and advanced does not accept that jurisdiction ratione personae against any crime, however heinous, has been lost to a sitting head of state as a matter of customary international law. Justice Lewis, I don't want to take up a particular time now dealing with the amici with your leave for these particular reasons. I want to say that we've endeavored to put into our submissions filed heads which have sought to answer 3 points raised by the Helen Suzman Foundation. And we submit that, I don't know whether...
Well, I was actually suggesting to my assistant presiding that perhaps this should be dealt with.
Well, that is exactly what I was contemplating doing with the court's leave. And equally, as regards the others, we have a few short points, but there really are points to be made in reply.
Let us let the amici and the hopeful amici make their points.
Yes.
And
Yes.
you may then reply to them.
I have one point on costs, and that is this, that if SALT loses, then it loses, we respectfully submit it gets no costs. If it, sorry, let me put it the other way around. If Biowatch would apply in ordinary circumstances in the relation to the bringing of important issues to the court, that we accept. We do say to you that there should be no entitlement under any circumstances, to costs in relation to the application for leave to appeal. This case had to be heard by this court. It's a vital case. And we say the persistence, without arguing it in heads of argument and requirement, as this court requires, should result in the fact that in this court, costs in relation to leave to appeal, and we spent a quarter of our pages on it, and you spent a lot of time, should be disallowed.
Yes, well, I think we should hear Mr. Trump.
Yes. Thank you,
Again,
Madam.
you.
Yes.
What does it mean?
Well,
It's not an
think
order I've ever come across.
my learned friend is an expert in asking for complicated cost orders, but I understand it to mean
What
119, the Lord say.
Yes. The applicant is entitled to the cost of the application
Yes.
on a pro bono basis.
Yes.
What does that mean?
My learned friend would perhaps better explain than me, but I think as I understand it, it means counsel appear pro bono, but where they fly or drive cars and arguably sleep in beds, which are not their own, that would be encompassed by that. But my learned friend will state it more accurately if I'm wrong.
These costs excluding costs of appearance of counsel.
As
The incidental.
as the court is.
May it please the court. The question in this case is whether President al-Bashir was immune from arrest under South African law when he visited in June last year. We submit with the greatest of respect that that the answer to that question is simple, because it lies in section 10(9) of the ICC Act, which is clear and unambiguous. It says that the fact that the person to be surrendered is a person contemplated in section 4(2)(a) or B, which includes a sitting head of state, does not constitute a ground for refusing to issue an order contemplated in subsection 5, which is an order for the surrender of that person to the ICC. So it's absolutely clear. There is no ambiguity to it. It means what it says. And it speaks not only of former heads of state, but it speaks of someone who is a person contemplated, i.e. who is a head of state. My learned friend's only answer seems to be, well, it can't mean someone who is a head of state. It must be confined to a head of state who has waived privilege or waived immunity. But that's an absurd outcome, because that means that what the section says when it refers to heads of state is that a sitting head of state enjoys all the immunities conferred on him by customary international law, except if he's waived, or he or his state has waived the immunity, in which event he shall enjoy no immunity. That is a complete absurdity.
Well, it requires changing meaning of both sections 4 and parts of
Same
of
argument
section
goes
10.
to both of them,
Yes.
indeed. Not only does one have to change the language, but change the obvious sense of the section. It says a sitting head of state does not enjoy any immunity against surrender to the ICC. That's the answer to the question in the case. Not only does that...
Do you submit, Mr. Trengove, that the effect of the provisions of the Implementation Act is to take away the immunity of a head of state conferred by Section 4 of the Immunities Act when that person has been charged with the crimes contemplated by the Rome
It
Statute?
amends the prior section to the extent of their inconsistency. And insofar as the one says all heads of state have a certain immunity, and the other one says that a head of state charged with an international crime does not enjoy immunity, the latter qualifies the former.
Not necessarily incompatible. If anything, they dovetail quite neatly with each other.
Yeah, indeed. But there's, the point is that Section 4.1 of the Immunities Act cannot be invoked to defeat the plain meaning of Section 10.9 of the ICC Act. And that's the end of the case.
Well, it would defeat the purpose of incorporating the Rome Statute.
Indeed, my lady. And let me say, the outcome of that very simple reading, that very simple answer to the case, is a happy outcome, because it also gives effect not only to the Rome Statute, to which South Africa has subscribed, but it also gives effect to the ICC Act. And we refer in this regard to the quotation from the Constitutional Court judgment in the torture docket case that we quote at the top of our page 10 of our heads of argument, where the court said, "Our country's international and domestic law commitments must be honored. We cannot be seen to be tolerant of impunity for alleged tortures. We must take up our rightful place in the community of nations with its concomitant obligations. We dare not be a safe haven for those who commit crimes against humanity." That goes all the more so for those who stand accused of genocide, of war crimes, and of crimes against humanity.
So your construction of the Implementation Act is this: if you're charged before a South African court, it's no defence to say I'm a head of state.
Section 4.1.
That's Section 4. If instead South Africa is performing its obligations to assist the court by surrendering, saying that I'm a head of state is again irrelevant. And the Act does not incorporate the Rome Statute. It attaches it as a matter of information. And Article 89.1 is not incorporated into the South African statute.
Mm-hmm.
Because 89.1 that has always caused this tension.
I think it's 98.
98.
Oh, sorry, 98.1.
Yes. Indeed.
Sorry, 98.1, yes.
Yes. We have simply chosen to replicate Section 27, which makes it clear that it doesn't matter where or by whom these crimes are committed, but that there will be no place to hide. That philosophy, that purpose would be defeated by this very strained interpretation, which incorporates, firstly, the Immunities Act, and through it, customary international law, and moreover, a very controversial interpretation of it. That is all very interesting, and I'm going to deal with it simply to demonstrate that even when one does, there is nothing in the Immunities Act or in customary international law that contradicts our interpretation of Section 10.9. But that is a negative purpose. One doesn't, the answer to the case is provided by Section 10.9, and one need go no further than that. I may just say I'm going to reserve the last 10 minutes of my allotted time for my learned friend, Mr. Du Plessis, who will speak about customary international law, of which he is much greater expert than I am. As far as the facts are concerned, may we just emphasize two things. My learned friend referred to the prior rulings of the ICC on the very issue before the court, and that's the immunity of President al-Bashir. And he suggested that there was a ruling given on a Saturday evening by a single judge sitting on his own and obviously opining on the South African situation. That is not correct. We mention at page 4 of our heads of argument, in paragraph 12, firstly the Congo case, where the ICC ruled in 2014 that the effect of the Security Council resolution was to strip President al-Bashir of whatever immunity he might otherwise have enjoyed under customary international law, and that there is thus an obligation under all ICC countries to surrender him if he set foot on their territory. So that's a clear and unambiguous ruling made a year earlier. And then, as we mentioned on page 5, at the time of his visit here, or shortly before his visit, the South African ambassador engaged with the ICC about his visit to South Africa. And it was again made absolutely clear to him that South Africa had an obligation under the Rome Statute to arrest and surrender General al-Bashir. That is dealt with in the ruling that we quote at page 5, and you'll see that ruling refers to the Congo judgment of a year earlier and the consultations with the South African delegates on 12 June. So it was emphasized to them that they are bound under under the Rome Statute to arrest and surrender General al-Bashir.
Well, Mr. Chinga, are you going to deal with the problem I raised with Mr. Gauntlet at the outset? That on my reading of the papers, all these fascinating arguments were not raised before the High Court. All that was raised there was reliance upon the AU agreement, the AU hosting agreement, and the proclamation. And in particular, for example, at paragraph 3.8, Dr. Lubisi, at page 107, says the Cabinet was fully aware that their decision only applied for the duration of the AU summit. There was never a rowing back from the position that had occurred when President Zuma was inaugurated, where the message to Sudan was, if he comes here, he'll be arrested. And the issue of arrest was never an issue below. The only question was there this immunity arising from this agreement? I know one of your learned juniors was actually there, but I'd be interested, that's my understanding of the papers. I would like to know if that is in fact what occurred.
That is also my understanding, but I'll check with the one of us who was there on that Saturday afternoon.
Sunday.
Because Saturday and then Sunday. Sunday and Monday, yes, indeed. Yeah. Now, if one then, but let me again say, all of this complication need not arise. It arises only because the government raises the complication and introduces the Immunities Act and Customary International Law.
Unnecessary for the purposes of law.
Quite unnecessary. My argument can stand or fall by section 10.9, and that's it. But if I may turn to the provisions of the ICC Act, the court has made it plain that the ICC Act explicitly in its preamble and its purpose sections makes it plain that its purpose is to domesticate the Rome Statute, so that it should be given an interpretation which gives effect to South Africa's obligations under the Rome Statute and makes them effective. The section 4.2 makes it clear that a head of state does not enjoy any immunity before the South African courts, and I quote, despite any other law to the contrary, including customary and conventional international law. So it's made absolutely clear that South Africa has opted to strip all heads of state, sitting and former, of whatever immunity they might otherwise have enjoyed under any other law, including customary and conventional international law. And let me say of that provision, we don't say that this provision is directly applicable because this provision we accept is concerned with criminal proceedings before the South African courts.
No, but it has to be read together with 10.9.
Indeed, the two are complementary.
10.9 means nothing without.
Indeed, the two are complementary, but we submit that the legislature adopted the same policy in the one as it did in the other. And the policy of both is that it doesn't matter who it is or where they committed the crime, they are liable to our jurisdiction, and we would not recognize any immunity.
And
South Africa is committing to bring those guilty of reprehensible crimes to book.
Indeed.
No matter their status.
Indeed. And what this section does is that it recognizes that there might be some controversy in customary international law, but what it says is that we have chosen, despite that controversy, not to recognize any immunity. And
then you read 10.9, because this is dealing with surrender to the court,
yes,
with the fact that when they get to the court under Article 27, when they say, but I'm a head of state, the answer will be that is irrelevant.
Exactly. Now we give effect,
as it always has been.
10.9 gives effect to 27.
Yes.
That is to say, because the court doesn't recognize any immunity, neither will we in discharging our duty to respond to ICC requests. And let me say, but while I am with Section 4.2, Justice Wallace, I submit with respect, firstly, Section 4.2 also speaks of anybody who is or was a head of state. It's again that clear language that makes it clear that it applies also to sitting heads of state. Our learned friend's suggestion that it only applies to a sitting head of state if his immunity has been waived anyway introduces the same problem I've addressed before. It's both nonsensical and requires a change of language. Our learned friends suggest in paragraph 54 of their heads that they seem to accept that when Section 4, which makes these international crimes punishable under South African law, 4.2 says nobody has immunity, 4.3 says and the courts have jurisdiction as long as the perpetrator is here. Now, our learned friends seem to accept that that means that a sitting head of state may be prosecuted, convicted, and sentenced to life imprisonment, but they say may not be arrested. Well, that is an absurd interpretation. Yeah, but that's what they suggest in their paragraph 54. The fact is that what 4.2 shows is that the South African legislature has chosen to make it clear that under South African domestic law, whatever customary international law might say, under South African domestic law, those accused of these international crimes do not enjoy any immunity at all, whoever they are, even if they are sitting heads of state. We describe from page 12 in our heads that scheme of the ICC Act to which Justice Wallace has referred, sections 8, 9, and 10. And if you follow that scheme, it prescribes 7 mandatory steps, each of which leaves no discretion for an inquiry into immunities of the perpetrator. I won't recite them now, but what is striking about them is that they say when the request comes from the ICC, it must be referred to the DG for Justice. The DG must refer it to the magistrate. The magistrate must endorse it. 9.3 says it must be executed. When the when the suspect is arrested and brought before the magistrate holds that very simplistic inquiry that Justice Wallace identified. 3 questions only. If the answer to the 3 questions are the right answer, he must order the surrender. There is no room in that scheme for an inquiry into the defense or claim of immunity. And that is the scheme that then leads up to 10.9, which makes it explicit that it doesn't matter who it is, even a sitting head of state does not enjoy any immunity against this process. Again, a process entirely in line with the purpose of the Rome Statute. Now, our learned friends deal with section 10.9 in their heads of argument in paragraphs from paragraph 55, but with respect never provide an answer to the ordinary meaning, the plain reading of section 10.9, namely that it strips a sitting head of state from any immunity against an order for the surrender to the ICC. We deal with that argument in our heads of argument from page 15 in paragraph 35, but because my learned friend did not reiterate that argument in his oral submissions, I won't dwell on it. And you will see that in that argument that they make on 10.9, that they place pivotal reference on an article of a Mr. Geerwitz, who asserts that the Act is silent on the question of on the role that immunity plays in a request for surrender to the ICC. Well, Mr. Gierdes just overlooked Section 10.9. It is impossible for him to have made that statement if he had known of Section 10.9. So that our learned friend's argument, based on Mr. Gierdes, for the interpretation of Section 10.9 is wholly misguided because it is an interpretation of a man who overlooked Section 10.9. He clearly was not aware of it when he made those assertions about it. And that, with respect, means that at the end of the interpretation exercise of the ICC Act, one comes back to Section 10.9. It stripped President Bashir and people like him of whatever immunity they might otherwise enjoy. And we commend in that regard the scholarly conclusion, the scholarly endorsement of that interpretation by Professor Clady, whom we quote at page 17 in paragraph 36 of our heads of argument, because that is precisely also how he has read these
Was he not an advisor to the government?
That is why we quote him with such relish. He is also a discerning scholar who quotes Mr. Duplessis. We mention at the top of page 18 that this approach is not a unique approach. In fact, it is the recommended and common approach. It's the approach commended by Professor Kasesi, internationally renowned scholar and former president of the ICC, which says that the prudent approach domestically is to exclude any immunity claims at the domestic level so that it can be resolved at the ICC level. And it is common cause that is also the approach that has been adopted by many of the members of the ICC. So that we would submit is really the end of the case. But we go on to customary international law, which we address at page 20. This is the topic that my learned friend Mr. Duplessis, which my learned friend Mr. Duplessis will elaborate. But let me say just 3 things about it. We accept that there is a general rule at customary international law that sitting heads of state enjoy immunity against prosecution in the domestic courts of foreign states. So we need not debate that proposition. We need not quote Professor O'Keefe, who says only that. That is accepted and it's irrelevant for our purposes, because the question is not here whether President al-Bashir should be prosecuted before our courts. The question is whether he should be surrendered to the ICC. We know that in
which the
South
arrest
Africa,
warrant case specifically distinguishes.
indeed, in South Africa,
The Rome Statute was not yet in force when that decision was handed down, but it is, in the majority judgment, expressly singled out as an exception.
The point, that is exactly the point. Even the bedrock of the argument for that immunity recognizes that there is an exception in favor of prosecutions of international crime before international tribunals. So the very rule, the very general rule on which our learned friends rely, have always allowed for, has since 2000 allowed for this exception in favor of international prosecutions of international crime. And so that when our learned friends quote O'Keefe or the Supreme Court of Canada to say that there is immunity at customary international law or under Canadian legislation against civil or criminal prosecution before the domestic courts, it's interesting but irrelevant to this case. This case does not concern a prosecution before a South African court. This case concerns the surrender of the suspect to the ICC for prosecution under for these international crimes. And there is just no learning to suggest that there is immunity against the exercise of that jurisdiction. We deal with the impact of the Security Council resolution from page 27 of our heads of argument. Because we submit in the first place that General al-Bashir did not enjoy any immunity against surrender, whether under South African domestic law or under customary international law. But if he did, then he was stripped of that immunity by the Security Council resolution.
Yes, I have some difficulty in understanding that argument because of the terms of the Security Council resolution itself. It decides a number of things, refers Sudan to the Security Council, it encourages cooperation, but doesn't seem to do any more. And I'm not sure that one even needs to get there, given the interpretation of sections 4 and 10.9.
No, one doesn't. But insofar as one's opponent suggests it's relevant, let me say this. It is paragraph 2 of the order. The order appears at page 201 of the SCA record, that's the application record. The Security Council resolution, I said. And it's paragraph 2 that is relevant. Well, let me read it with 1 because the two go together. 1 says the Security Council decides to refer the situation in Darfur since 1 July 2002 to the prosecutor of the International Criminal Court. And then 2, decides that the government of Sudan and all other parties to the conflict in Darfur shall cooperate fully with and provide any necessary assistance to the court and the prosecutor pursuant to this resolution. The argument is simply that, and that order is binding on Sudan.
Yes.
Not binding on South Africa, but it's binding on Sudan. And the argument is simply, argument accepted by any number of international scholars, that the order that Sudan shall cooperate fully with and provide any necessary assistance to the court simply does not leave any room for Sudan to invoke.
What about the second half of that paragraph? I mean, why did they go on to say, while recognizing that states not party to the Rome Statute have no obligations under the statute, if that was not a recognition that Sudan is not a party to the Rome Statute? Surely that's the very thing they're saying is, we want you to cooperate fully, we recognize you're under no obligation to do so, but we urge you to cooperate fully.
Yes, but that would go for the rest of us, not Sudan.
Well, why would they put it in for the rest of us? They weren't thinking about the United States and India and Great Britain and Russia and China and other small countries that aren't signed on to the ICC. They were concerned with the fact that they were telling Sudan they wanted it to cooperate, and Sudan isn't a member. And it isn't bound. Surely
yes,
that's what the second half's about.
Well, let me say, I do think that there are two parts to the paragraph. And let me just make clear that the first part is an express order on Sudan to cooperate. Because it says that decides the government of Sudan and all other parties to the conflict in Darfur shall cooperate fully. Now, we would submit that we don't need to go any further than that, but let me just go then to the second part. Shall cooperate fully with and provide any necessary assistance to the court and the prosecutor pursuant to this resolution. And then it seemed to us that they then turned to the rest of the world, having ordered Sudan to cooperate. It says, and while recognizing that states not party to the Rome Statute have no obligation under the statute, urges all states and concerned regional and other international organizations to cooperate fully. So Sudan is ordered, the rest of us are urged. But whatever the second part might mean, we submit that the first part is an order on Sudan to cooperate. An order on Sudan to cooperate doesn't leave, a binding order on Sudan to cooperate, doesn't leave any room for Sudan to invoke immunity to which would frustrate the prosecution of the perpetrators.
So there's no waiver of immunity. No. Sudan becomes bound on your argument by virtue of the resolution itself.
Exactly, my lady. And our learned friend's only argument was an argument that turned on the meaning of waiver under South African law. We accept fully that waiver might be, and that's a term used internationally, but and it might be inappropriate to speak of it as waiver, as we know waiver as being an abandonment by the rights holder itself of its right.
You're talking about a removal of immunity.
It's a deprivation or removal or a stripping, but it's a superior authority that has ordered it to act in a way which doesn't allow it to invoke any immunity.
And why does this bind Sudan, which is it's made under Chapter 7 of the Charter? Of which provision of this Chapter 7?
Yes, we quoted it in our heads. I think it's Article 48 or 49, which...
Some of the academics referred to Article 20, but I'm not sure that's right.
Let me just find it. No, I think we quoted it where we dealt with the facts.
I think you suggest because Sudan is a member of the UN, it is binding.
Yeah, you'll find it on page 2 and paragraph 5 of our heads of argument, where we say that the Security Council exercised that power under Chapter 7 of the UN Charter. That's the power that even allows armed intervention, and that Article 48 obliges members of the UN to give effect to the determination, and 49 adds that all members of the UN shall join in affording mutual assistance in carrying out. So it's Articles 48 and 49 that would oblige Sudan to comply. We deal with the Genocide Convention at page 33.
May I ask Mr. Chengo, do you or Mr. Duplessis or somebody else on your team have those conveniently to hand, because they are not included in your bundle of documents?
Which is that?
Articles 48 and 49.
We'll certainly do that. I think we have them here, but we'll certainly let you have them.
Okay.
We have nothing to add about the Genocide Convention because some of my learned friends for the amici will deal with it. But again, we submit that the express exclusion of immunity under Article 4 is unambiguous, and there's no reason, again, to give it a restricted meaning. That would be another reason to conclude that President al-Bashir was not immune, at least insofar as he was being accused of genocide.
That's the second warrant. It's the second warrant.
Indeed, yeah.
Yes.
It brings us to the Immunities Act, which ultimately becomes the foundation on which our learned friends today contend that there was immunity. Now, may I say 4 things about the Immunities Act? Section 4.1, more particularly. Firstly, the point raised by Justice Wallace, and that is that it gives immunity from, quote, the criminal and civil jurisdiction of our domestic courts. We submit with respect that when a magistrate acts under Section 10, he does not exercise criminal or civil jurisdiction. He might be a court. It doesn't help for my learned friend to say, look at Section 10, it speaks of a court. He might be a court, but the function performed is an executive or administrative function of providing international assistance to the ICC in accordance with the ICC Act. So that we submit that the section does not even engage this exercise. But secondly, we submit that on a
Sitting as a court, how would you characterize the function being performed, though?
We submit that it is an administrative function or an executive function. As was suggested by Justice Wallace, it could as well have been performed by the DG of Justice.
It's because the magistrate has to make no decision. He's not faced with any choice.
It's an administrative decision. It's like a policeman who makes an arrest with a view to a prosecution. The policeman doesn't perform a judicial function. He arrests and surrenders to the court, who then performs the judicial function. In this case, the magistrate performs an administrative or executive function with a view to a prosecution, with a view to the exercise of the criminal jurisdiction of the ICC, not the criminal jurisdiction of the South African court. But secondly, we submit, even if the section is engaged, then we submit that on a proper reading of the section, it affords no greater immunity than a head of state enjoys under customary international law. And that is an immunity against prosecution in the domestic courts of another state. As we have submitted, my learned friend will explain, customary international law does not afford an immunity to heads of state for prosecution of international crime before international tribunals. So that even if the section applies, it would not immunize President al-Bashir against surrender to the ICC, because customary international law does not protect heads of state against prosecution before international tribunals. That's the exception recognized in paragraph 69 of the arrest warrant case in the first place. Thirdly, even if we're wrong on the first and second point, President al-Bashir has in any event been stripped of whatever immunity he might otherwise have enjoyed, in this case, by the Security Council resolution. In the fourth place, even if we're wrong on 1, 2, and 3, even if there is some immunity left under Section 4.1 of the Immunities Act, it is trumped by the ICC Act, Section 4.2 and Section 10.9. And we have addressed the reasons why it trumps the Immunities Act. It is so obvious. It is the later act, and it is the more specific one, dealing specifically with heads of state being accused of international crime.
But it's introducing an exception to the normal rule.
Indeed.
To the rule of customary international law that is embodied in the Immunities Act.
Indeed, madam, that is so. So that we would submit that there is no joy to be had from Section 4.1 of the Immunities Act. It leaves, lastly, the host agreement. Well, whatever else one might say of the host agreement, it simply does not confer immunity on heads of state. And we quote it in our heads of argument at the foot of page 35. And we submit that the text makes it absolutely clear that its purpose was confined to immunity afforded to the international organizations and their officials who would attend the conference, not in heads of state. Even when it speaks of delegates, it speaks of delegates of certain international organizations. If I may just quote the language as we see it here at the foot of our page 35. The people on whom the immunity was conferred are the members of the Commission, that's the AU Commission, and staff members, the delegates and other representatives of intergovernmental organizations attending the meetings, the representatives of the intergovernmental organizations, and the observers accredited to the African Union. None of those categories include visiting heads of state. All of them clearly are confined to international organizations and their officials.
Well, and is that right? You say that delegates and other representatives are both qualified of intergovernmental organization. But in fact, in Article 8.3, there's no reference to delegates of intergovernmental organizations, it's only representatives. Surely there are three categories. There's the members of the Commission and staff members, there are the delegates, and there are the other representatives.
Well, I've lost you. Are you reading from my
Article
text?
8. Article 8, Part 1. Have you got that? It's at page 83 of the record.
May I just get it?
See, you've read it as being, it says the government shall accord the members of the Commission and staff members, the delegates and other representatives of intergovernmental organizations. In your heads, you say that delegates and other representatives both are relate to intergovernmental organisations. It's delegates of intergovernmental organisations and representatives. I'm suggesting to you it isn't, that it's delegates separately and then other representatives, and that's confirmed by Article 8.3. Because on your construction, 8.3 would have to read the delegates and representatives.
No, with respect not. 8.3 says the representatives of intergovernmental organisations.
Yeah, but why would you exclude the delegates of intergovernmental
Whose
organisations?
delegates? I submit with respect, let me say this, that if you look at the section under which this immunity was conferred, it is section 5C.
Yes.
It is a section which is confined to immunity conferred on international organizations and their officials. And it stands in contrast with section 7.2, which concerns the conferral of immunity on heads of state. So the starting point is that this immunity is conferred under a section which is confined to international organizations. And we submit with respect that that purpose is entirely consistent with the text, because if I may pick it up in 8.1, the government shall accord 1, the members of the Commission, that's the EU Commission, and staff members; 2, the delegates and other representatives of international organizations attending the meetings. And then if I jump to 3, the representatives of intergovernmental organizations and the observers accredited, etc.
It's the second one, Mr. Tringo. I'm sorry, the way I read it in your heads and the way I hear it as you read it, you're talking about delegates from intergovernmental organizations as opposed to delegates to the Assembly. Is that wrong? Have I misunderstood you?
I read it as delegates of intergovernmental organizations.
That's what I thought. I'm putting to you that that's an erroneous reading, that it's the delegates to the Assembly, and then it's the representatives of intergovernmental organizations, and that Article 8.3 makes that perfectly clear, because otherwise 8.3 would have to start with the delegates and representatives.
The difficulty is that one has to take into account the heading of Section 5, which makes it clear that it's dealing with United Nations, specialized agencies, and other international organizations. So it's not dealing with the states or their representatives or their delegates. It's dealing with people who are facilitating meetings of some kind or other.
And just as well as I agree that there is not complete synchronicity between 1 and 3. And in fact, you will see in 3, it also extends to another category, and that is observers.
Yeah.
But under 1, to read delegates as a freestanding category would raise the question of delegates of whom and to what? Whereas the answer, delegates of intergovernmental organizations, gives a ready and seemingly obvious answer to that question. But we do submit that firstly, that it was, the immunity was conferred under a section which is confined to immunity of international organizations and their officials. And the text is at least compatible with an interpretation which so confines it within the parameters of that section. And therefore that the immunity was limited. Even if we're wrong, this subordinate legislation can't, with respect, in any way contradict or amend.
What do you say about the proposition I put to Mr. Gauntlet that a head of state is not a delegate of a country? A head of state is the country for these purposes. The delegates are somebody else, but the head of state is the head of state.
Indeed, delegate, somebody who comes here with a mandate given to him by a principal. So we submit that whatever that interpretation, it also does not advance our learned friend's case. Let me lastly say something about mootness and leave to appeal at cost. The only reason why we did not perpetuate the mootness argument in our heads of argument is this. The order made by the court, which is at page 115 of the papers, of the SCA papers, that's the application, is that the respondents are forthwith compelled to take all reasonable steps to prepare to arrest President al-Bashir. We argued before the High Court that there was no reasonable prospect of him visiting again, and therefore that order had become moot, and the court so held.
But the first order is not moot, is it?
I beg your pardon?
The first order
Yeah.
is not moot.
No.
It's not of academic interest only, and that relates to the government's failure to comply with the Constitution.
Indeed. That's not moot, but that did, as Justice Wallace pointed out, refer to their past conduct. But let me say, what made a difference was that the government then announced that the government didn't announce. The media reported that the government again wanted to invite President al-Bashir to the country. And that issue is dealt with in the self-answer to the application for leave to appeal, page 140 in paragraph 79. And it refers to media reports, of which one is annexed at page 218 of the papers, to the effect that it says al-Bashir gets green light for return trip. Now, once government said that it wished to invite him again, and we couldn't demonstrate that that was not so, one has to accept that the order that they arrest him when he sets foot here is no longer moot. And for that reason, we did not persist in the mootness argument. We do persist in the opposition to the application for leave to appeal on the basis that the appeal doesn't have reasonable prospects of success. The appeal fails on a proper interpretation of Section 10(9) of the ICC Act. Now, whether you refuse leave, whether you grant or grant leave and refuse the appeal is much of muchness, but we do submit that there is a plausible and a reasonable basis upon which we persisted in our opposition to the application for leave to appeal. So we do ask for the appeal to be dismissed and for costs, including the costs of free counsel.
Before you pass the baton to Mr. Duplessis, is paragraph 1 of the order, is that appropriately worded? It's painted in very, very broad stripes to say something is inconsistent with the Constitution and invalid. Would it not be more appropriate to say that is inconsistent with South Africa's obligations in terms of sections 8 and 10 of the Implementation Act? Or something of that sort.
Yeah. Let me say that in the on a hot afternoon and an urgent application, this was a commendable order. But with the benefit of hindsight, it can and should be more precisely honed.
And is it a matter of arresting without a warrant in terms of the Criminal Procedure Act, or is it a matter of executing a warrant which has been issued by the ICC?
Indeed, the first warrant has indeed been endorsed by the magistrate and lies there.
Sorry, so there's an extent warrant that has been endorsed by the Chief Magistrate, well, certainly as far as the first one is concerned.
Yes.
One's not sure what happened to the second one.
Indeed.
Which also, certainly, my little brain, it causes all kinds of confusion because you had the Director General then take this international warrant, have it endorsed. Presumably, one thought that that would be acted upon.
Yeah.
And now you've got government coming to court to say, clear the way for the man to return to the country.
Yeah. It shouldn't have been so. So that you had a warrant that had to be executed. The second ICC warrant had probably also been endorsed by a magistrate. The facts just weren't canvassed in the papers. But what should have happened is that the state should have been ordered to give effect to those warrants and to be executed.
Would it not be more appropriate to word paragraph 2 in that event as not in terms of the Criminal Procedure Act, but in terms of the Implementation Act, to say that these warrants are the ones
Yes, I think that was an attempt to capture Section 9.3 of the ICC Act, which in turn says that such a warrant must be executed in a manner as near as
possible to the
possible to the, I think it's Section 20 of the Criminal Procedure Act.
And is Mr. Gauntlet's explanation of costs on a pro bono basis correct?
Yeah, what it means is that the lawyers acted pro bono, but there were expenses incurred, and so whatever rules apply when the lawyers act pro bono are the rules that should govern that cost order.
And on appeal?
Assuming
we're against you?
No, well then by all.
Mr. Duplessis, your leader said that you wanted about 10 minutes. We will keep you to that.
I'll do my very best to keep to that with the court, Steve. As my learned leader has already made it clear to the court, whatever the state of customary international law, and we know what the position is that our learned friends come forward, it's an absolute position. Whatever that position may be, of course, it's cut past by our Parliament through the immediate answer to whatever the difficulties may be. But I'm going to just spend the 10 minutes to show you that there isn't in any event an inconsistency, because customary international law certainly permits states to cooperate towards the prosecution of international crimes in international criminal tribunals. There's, in other words, no prohibitory rule in customary international law. And the government's invocation of the arrest warrant decision to push for this blunt and prevailing immunity with respect is wrong. As your ladyship presiding highlighted, already the arrest warrant decision itself appreciated that it was on the cusp of a change in 2002. And we recognize this at page 21, paragraph 42 of our heads, where it was noted that the future International Criminal Court, together with Article 27, was going to provide an opportunity for a gap. It recognized a gap already then in 2002. And for 4 reasons, which will hopefully take no more than 10 minutes, I'm going to suggest that it is wrong not to recognize that that gap has opened. It is wrong to attempt a reification of customary international law, as our learned friends do, to 2002 with arrest warrant.
I'm sorry, has the gap opened or closed?
Well, the gap is opened in as much as there is a rule in international law which ordinarily pertains to a head of state, and it means that you can't be prosecuted before a domestic court.
But that has changed.
That has changed. So there is a change in the prohibition. And that change is that you are not permitted to do so where you are in an international criminal tribunal, and you are certainly permitted to do so as a state under the Rome Statute, attempting to cooperate with that international criminal tribunal to ensure the prosecution of such a person. And it's therefore wrong to reify customary international law to 2002. It's also wrong to ignore the developments since 2002. And with respect, it's wrong to ignore the context in which this case is taking place. The arrest warrant decision of the International Court of Justice dealt with one state attempting to assert jurisdiction over the foreign minister of another state. That was what that case was about. It had absolutely nothing to do with an international criminal prosecution by an international tribunal, and it said nothing about the attempt by a state to act, in a sense, as a conduit for such an international criminal court. And 3 months after the International Court of Justice's decision, you have the Rome Statute of the International Criminal Court coming into effect. And you have then a rapid cascading of developments, which with respect need to be taken into account. You first of all have the Rome Statute itself, which in its provisions makes extensive reference to the duties on states to arrest and to cooperate with the International Criminal Court in order to ensure that there is ultimately accountability for genocidaires and others committing those crimes. And we are now at a place in international law where there are 123 states parties, as we stand today, as far as I could check last night, 123 states parties to the International Criminal Court, a very significant number indeed. And the cooperative regime and the duties that are placed upon states parties to assist in arresting is very pertinently highlighted by Professor Clady. It is in our bundle of authorities. I won't take you to it, but it's at page 322 and 323 of SALC's bundle of authorities. And it's also referenced by Professor Kande of Oxford at page 118 of our authorities. In addition to the Rome Statute's provisions itself, of course, then there are a number of implementation acts which are passed by a number of states around the world in order to give effect to these obligations. And with respect, we do need to turn to those in order to highlight that South Africa is in very good company under Section 10.9 of its provisions. If one has regard to Professor Kande, and this is in our bundle of authorities at page 149, and if I might just read it to you, it is in Salk's bundle from Professor Kande's article of 2009 in the Journal of International Criminal Justice. He says the following in the final paragraph on the page. It says, finally, the practice of the parties to the ICC statutes suggests that they view Article 27 as removing immunity not only at the stage where the defendant is before the court, that is before the ICC, but also at the national level. Professor Kande says a number of states have adopted domestic implementing legislation which implicitly or explicitly take the view that officials of other states may not be entitled to international law immunity from arrest when a request for arrest has been made by the ICC. And this is an article written in 2009. Already there he references in a footnote at that page, at page 19, the following states that have effectively done what South Africa has done through Section 10.9. They are Canada, New Zealand, the United Kingdom, Switzerland, Malta, of course, Croatia, Trinidad, Tobago, Ireland, Samoa, Estonia. That's at 2009. Our learned friends in their heads of argument add two further authorities to that effect, which are against them, which suggest that 10.9 is also done in Uganda and Kenya through their implementation legislation. And then I just would draw to your attention that Professor Kande highlights that section in that footnote, that Section 25 of the Commonwealth Model Law. So the Commonwealth Secretariat has drafted a model law on implementation for states that have become a party to the Rome Statute. And Section 25 of the Model Common Law replicates what we have in Section 10.9. And Professor Kande does that. I see, Justice Wallace, you're trying to find it, but it is at page 149 of the SALC authorities. Of course, aside from domestic legislation that highlights how Section 10.9 works in a number of other states, we also have the fact that there are ICC decisions and Security Council referrals which have taken place and which the arrest warrant decision could never have taken account of because they all came after that fact. And yes?
This cascading is Disraeli's difficulty with statistics. You say to us that there are 123 states parties as at last night, but unless something happened dramatically, China, India, Russia, the United States are not states parties. And we only need to add a couple of other things to say that half the world's population is not in any way party to or bound by the ICC. Now, which set of statistics should we take as reflecting customary international law? This is of no concern. Britain, I think, is not a party to the convention, but it does have an act to facilitate working with the ICC.
No, it is a party.
Or is it now a party?
Unfortunately, customary international law is not an absolute game, Justice Wallace. We don't need to show that there is universal acceptance. It is a widespread practice. And a widespread practice with respect of 123 states parties out of 190 odd in the world would be suggestive that certainly those states, together with the idea of the International Criminal Court and its regime, recognize that there is, for them and in respect of their practices with each other and the court, certainly an understanding that there is an exception to this absolute prohibition that our learned friends invoke.
Is the fact that we were the first African state to become a state party and to put this into implementation?
We weren't the first state party. Trinidad and Tobago was the first state party, but we were the first African state party. Yes, Justice Majid, you're right. We were the first African state party.
Surely that's what's important in this case.
It is important because we have a leadership role in that respect, and in other states, certainly African states, have looked to us for that leadership. And it is then a permissibility. It is an opening which permits states to do this. It's not to suggest that the international law rule is now confirmed in this way. It's that there's a permissible exception to the ordinary arrest warrant, customary international law prohibition that our learned friends invoke. And that exception is an exception which pertains to these types of cooperations where states act as conduits for the purposes of international criminal justice to be achieved before the ICC. There's a final aspect which hasn't been in any way taken into account by the arrest warrant decision, and our learned friends still don't properly deal with it, and that is that the arrest warrant case didn't deal with genocide. It was dealing with crimes against humanity and war crimes. This is a genocide case in respect of President al-Bashir, which really is a very important feature of the matter. So in those contexts, there have been developments, and they certainly need to be taken into account. They lead Professor Dugard, this is the second point, to highlight that there is a distinction that one needs to draw when looking at this customary international law rule and whether the arrest warrant decision can be made applicable to this type of case. There's a distinction between proceedings before international courts and domestic courts. And Professor Dugard himself highlights that there have been state practice developments highlighting that where cooperation is requested by an international court, whatever the immunities may be for a sitting head of state or some other senior ranking official, those immunities do not stand in the way of a state cooperating with that international criminal court to hand over for surrender. And we cite those in our heads of argument at paragraph 44. It's enough to highlight the Milosevic example and the example of Charles Taylor. The third point, very quickly, is that our learned friends suggest that there's no authority that they can find which suggests that a domestic court has ever done this. Well, there is. The Kenyan courts did it in 2011. Of course, there is an endorsement, at least, of an arrest warrant, as Justice Pono highlighted, by a South African magistrate in 2009, which has never been set aside. The government has never disavowed it. It stands. So we have certainly seen developments taking place, and they're developments that are consistent with the Rome Statute's views of attempting to ensure accountability for these types of criminals through the cooperation of a domestic regime with an international criminal court regime. Fourth point on this, and the final one, is that, of course, one has to recall that in any event, the arrest warrant decision by the International Court of Justice involved states other than South Africa. It was Belgium and Congo. And it's not binding on, this court's not binding on South Africa in two respects. It's not binding at the international level, because Article 59 of the Statute of the International Court of Justice, and Justice Wallace, we will make that available as well to the court when we hand up the provisions that may be of assistance to the court. But Article 59 of the Statute of the International Court of Justice says the decision of the ICJ has no binding force except as between the parties and in respect of that particular case. And Professor Crawford, writing in the 2012 edition of really what is probably the leading international law book in the world, Brownlee's Principles of International Law, at page 60, says this. He says, a decision of the ICJ, even one concerning substantially the same issues before a national court, does not itself create a res judicata for the latter. So it's entirely open to this court to decide what it thinks is the current state of international law. The ICJ's decision is certainly not binding on it. If there was any court to which your ladyship and her brothers were to look for guidance as to the gap in customary international law that has opened up and which permits states to cooperate with an international criminal court in arresting a head of state even though he has immunity ordinarily under international law, where better to look than the International Criminal Court's decision? My learned leader, Mr. Trengrove, has already highlighted that wasn't a decision made somewhere late at night. It was made by the pre-trial chamber of the International Criminal Court. It was made referencing previous decisions of the International Criminal Court. And it is an International Criminal Court decision in respect of South Africa. It is the International Criminal Court decision in respect of South Africa in relation to this very accused. And it is an International Criminal Court decision in relation to this very accused that the International Criminal Court says no longer has immunity because of a Security Council resolution, emphatically. So to the extent that there's any guidance to be sought, Justice Wallace's question earlier to Mr. Gauntlet, where is customary international law sourced? The answer correctly by Mr. Gauntlet was, well, one looks to international tribunals. Absolutely. The one in point has to be the International Criminal Court's decision, the one rendered against South Africa on the 13th of June last year.
It's not for this court to run ahead of international tribunals. It's not for us to sort of become path breakers, is it?
Not at all.
Because that's not what the Constitution says, that international customary law is part of our law. It doesn't say that we're to go out and make it.
Absolutely, but fortunately, this court is in the happy position of not having to do so, because the expression of what customary international law is in this case, in this context, in respect of this accused, in relation to this country, has already been made by the International Criminal Court. It has said in a judgment that there is no customary international law immunity that bars South Africa assisting in the arrest of President Bashir and surrendering him to the International Criminal Court. That is where one looks to for an understanding of what the gap is in customary international law with respect. So the government, to try and round off this point, I appreciate 10 minutes is going rapidly, but the government makes the mistake of treating customary international law as both static and blunt. As we've shown, whatever it was in 2002, it's moved on. It has moved on under the weight of rapid developments through the International Criminal Court, through the Security Council's resolution, and it has done to, ultimately, the effect of trying to hold accountable such individuals. It's also not a blunt rule. As we say in our heads of argument, at page 26, paragraph 49, again with reliance on Professor Crawford, now Judge Crawford of the International Court of Justice, immunity exists as a rule of international law. Sure, we accept that. But its application, says Judge Crawford, depends substantially on the law and the procedural rules of the forum. Here, if you stack up what those procedural rules are and the forum, we're talking about the South African ICC legislation. We're talking about the Security Council resolutions in point. We're talking about an ICC decision against South Africa. Those are the stacking up factors which tell you what the application is of the otherwise blunt rule of international law that our learned friends would seek to invoke.
So you're saying there's been a process of development of the law relating to immunity, somewhat similar to the process that occurred with commercial immunity until, 1918, 1920, courts wouldn't touch an asset owned by a foreign state. But then over the next 40 years, when foreign states started to engage in trading operations, they started to say their ships could be arrested, their trading activities didn't fall within immunity. You say this is a similar progression that's occurring in regard to international crimes.
Yes, Justice Wallace. I mean, Lord Denning in Trentex started that movement towards the commercial exception. We are seeing precisely under the weight of international criminal law, the Rome Statute, the state practice that goes with it, the arrests that have been issued by the International Criminal Court, and the judgments by the court, we see precisely that development.
It dates back to Nuremberg, originally, because that's the first one.
It does go back to Nuremberg, yes. So there's one final impact on this understanding of customary international law, which I'll finish with, and that is the weight of the Security Council resolutions. Justice Majid, I think, raised it first. It's this question that we are dealing with a case before the International Criminal Court that got there by virtue of Article 13b of the Rome Statute. The court gets jurisdiction only over states parties, or by the prosecutor deciding to open a case, or by the Security Council referring a situation to the court where it is a situation in a non-party state. That's how Sudan, as a situation, got before the International Criminal Court. And when that Security Council Resolution 1593 referenced the genocide and the situation requiring, ultimately, the International Criminal Court's attention, the Security Council did so under Chapter 7. Those are unbelievably powerful powers. Chapter 7 of the UN Charter allows the Security Council to use all necessary measures, code language for force, to invade. Or it can create international criminal tribunals, as it's done in the International Criminal Tribunal for Yugoslavia and Rwanda, or as it's done here, sending a case to the ICC. It does so because it recognizes that these types of situations are a threat to world peace and security. It's not a trifling matter. And we know from the arrest warrant, the second arrest warrant in respect of genocide, that that arrest warrant suggests that the genocide with al-Bashir in power is a genocide that continues. It's not past conflict. It's a genocide that is continuing. Our learned friends of the amici will pick up that point further. So it is a vitally important moment to realize that there is this Security Council resolution. And in the scheme of the way that the Council works, it has effectively made, for the purposes of the way that the statute works, it has made Sudan a party to the Rome Statute. It has done so. It has the power to do so through Chapter 7. So all the provisions of the Rome Statute are now applicable to Sudan, including Article 27, which says you have no immunity. Sudan is therefore, for purposes of the Rome Statute, as though it were any other state, and its head of state has no immunity before that court. That's what Security Council Resolution 1593 has done. Our learned friends for the government attempt to get round this point, and they do so with reliance effectively on one academic. In their heads of argument at page 36, paragraph 68, they rely on a Mr. Kiani, There are 4 problems with this, with respect to them. The first point is that Mr. Kiani is something of a dissident and lone voice. His article appears in the Chinese Journal of International Law. The second is, in the abstract of his article, he says that contrary to most commentaries, it's important.
Sorry, that may be a contradiction in terms.
I'm not saying anything further, but he does say, Justice Bonan, he says, in his own abstract.
I'm just being facetious.
I'm not taking it further, but what he says is contrary to most commentators. These are his words about his own article, which they're referencing as getting round the Security Council resolution quandary for them. His own article says that contrary to most commentaries, this essay argues that Bashir remains protected by head of state immunity. So he is a lone and dissident voice. And Professor Clady notes, at paragraph 54, page 29 of our heads, we've referenced him, that this lone dissident voice is entirely contradicted with respect by the great and the good of international law. We reference them at page 29 of our heads of argument. There's Professor Akande, who's a professor of international law at Oxford, and with respect, he's the leading writer on this area of immunities in the law. Professor Slater, Professor DeVette, and...
So I'm afraid I've never set much store by counting academic heads.
Well, let me then finish with at the very least highlighting that without counting her, but putting her forward with respect as the leading authority on immunities, a recognized immunity authority, quoted extensively in the Pinner judgment, Lady Hazel Fox QC. And that was what I registered in Chambers, Your Ladyship presiding, was the authority that we'd wish to hand up to the court. It is, I think we've got the copies here, if I may hand them up. The only reason we're handing it up, well, there are 2 reasons. The one is that Lady Hazel Fox QC is the recognized doyen of the law and immunity. The second reason is that, for reasons which are related to the pace at which we were preparing, we were only able to get the latest edition of her book recently. And the latest, the 3rd edition of her book is 2014. And I would simply draw your attention to page 558 of her book, where she says, this question has arisen before the ICC in the context of an arrest warrant for the incumbent president of Sudan. Pre-trial chamber held that customary international law creates an exception to head of state immunity when international courts seek a head of state's arrest for the commission of international crimes. The fact that the situation in Darfur was referred to the ICC by the Security Council pursuant to a Chapter 7 resolution is significant, she says. According to Articles 25 and 103 of the UN Charter, so we might add those to our bundle when we give them to you in addition to 48 and 49, Articles 25 and 103 of the UN Charter, member states are obliged to carry out Security Council resolutions even if they conflict with any other international agreement. And the removal of immunity in this case is thus a function of the Charter law operating in a specific situation. She says that even though the pre-trial chamber did not use this argument in its decision, in other words, this is her argument, but now you know that the pre-trial chamber that she's referencing is the earlier decisions. We've now got decisions of the ICC pre-trial chamber, including one binding against South Africa, where they say specifically that the Security Council resolution has then removed the immunity. So with respect, we then come finally for me to just conclude by saying we submit with respect that customary international law does not assist the government in this appeal. But as Mr. Trengrove has explained, whatever the state of customary international law, whatever the debates may be, for this appeal, the International Criminal Court Act that South Africa adopted trumps through Section 332. And our Parliament has cut its way past this controversy. Section 10.9 really is the easy answer to the case. But to the extent that you wish to interrogate customary international law, then you can do so safe in the knowledge that there certainly is a gap that has opened up for precisely this type of example, to hold precisely this man accountable, and in respect to a decision which is against South Africa by the tribunal that wants its hands laid upon it. Thank you very much.
Thank you. Yes, the court will take the lunch adjournment now, but we will resume at 2 o'clock, not 2:15.
but particularly B and C, also reference the question of immunities. They are not solely concerned with the question of privileges, and you'll see that from the express language in B, and in C by reference to 7.2, which also by reference has an impact upon immunities. Therefore, on a coherent reading of the provision, one would, in our submission, have to understand that A, B, and C are the conditions under which immunity or privilege is to be enjoyed. That's as a matter of interpretation. The second postulate that we would advance and submission made in respect of the interpretation of Section 4.1 is that it appears from the interpretation offered by the government that it attaches very significant, a great deal of significance to the comma after republic, to suggest that that is a self-standing provision and that what follows is therefore subordinate and doesn't engage with the primacy of the introductory language. We say that too is not a correct reading because, for the reasons that I've already given, A, B, and C give content both to the question of immunity and to the question of privilege. And therefore, for the government to sustain its argument, it must ultimately locate the immunity for the purposes of this case in 4.1a, and hence it engages directly the question of what are the rules of customary international law as interpreted under our Constitution. Now, you've heard from our learned friend as for South, Mr. Duplessis, as to how customary international law may come to be interpreted. But the force of our arguments are different, which is to say, in giving an interpretation to 4.1a, we say that the Constitution has reference, and in particular, Section 232 of the Constitution has reference for the purposes of understanding how we are to interpret the reference to customary international law in 4.1a. Now, to do that, we would submit to the court, firstly, that the express provisions of 232 are to enshrine in our Constitution the basic premise that customary international law is law in the Republic unless it is inconsistent with the Constitution. So that raises the question, well, what part of customary international law might be inconsistent with the Constitution? Because we say a constitutionally compliant reading of the reference in 4.1a must be to customary international law in a compliant fashion with the Constitution. Our submission is that the Constitution indeed has things to say about what duties the state has in respect of international crimes. And we derive that from two fundamental sources. The first is that this, the case has made express reference in paragraph 32 to what it calls the duty to suppress. So it
is
has,
that the judgment of the Constitutional
in the Constitutional Court, yes. It is said in paragraph 37 that in respect of torture, there is a duty upon the state to suppress, and that arises quite apart from international treaty obligation. Now, we submit that in a case concerning genocide, there is simply no reason to distinguish the torture, the position in respect of torture, and the position in respect of genocide and crimes against humanity. Because what it says is, along with torture, the international crimes of piracy, slave trading, war crimes, crimes against humanity, genocide, and apartheid require states, even in the absence of binding international treaty law, to suppress such conduct. And so the constitutional commitment is that in respect of the very crimes which are the subject matter of these proceedings, there is a constitutional duty that rests upon the state to take such steps as are necessary to suppress. That's the first source of the constitutional duty that we say arises.
Is this the submission that there is a positive obligation imposed?
Yes, yes. And that is quite apart from the obligations that arise from the Rome Statute itself.
And it would be directly contrary to Section 4 if it is interpreted as the applicant seeks to do.
Indeed, indeed. So we say the correct constitutional interpretation is in the light of that duty. And we derive the proposition as to the content of the constitutional obligation from another source, which is Section 7.2 of the Constitution, which in the Glenister case, where it was found that in respect of corruption, there is also a duty upon the state to take steps to eradicate corruption. Now, again, we say, by parity of reasoning, where there are rights at stake, and we say, as I will explain in a moment, why there are rights at stake, it would be similarly of application under 7.2 that steps must be positively taken by the state to suppress, in this instance, the international crimes that are at stake in respect of the warrants that have been issued against President Bashir. We developed briefly in our heads of argument why it is that rights are implicated by these kinds of crimes, and we referenced an academic article by Professor Lupin, who asks the question, what does it mean to have a crime against humanity? And we would just make this very brief submission on this score. There's a difference between a civil wrong, a delict, and a crime. A crime is an offence not just against the victim, but is against the community in respect of which those norms apply. In respect of crimes against humanity and genocide, what is said in the Lupin article is that this deals with an even wider range of interests which concern all of our interests in a world order that is not degraded by these kinds of crimes. And consequently, we do submit that there is a right to dignity not to have these crimes go either unpunished or persons come to this country with impunity in the face of the allegations that have been made against President Bashir in respect of these matters.
That there is no impunity, just that we can't do anything to encourage it.
The proposition that we would advance, though, is to say that there is an active duty that rests upon the state to take such steps as are necessary in order to ensure that these kinds of crimes do not go.
And to whom is the duty owed?
To whom is the duty owed? Yes, the duty is owed, as was found in Glenister, to all South Africans and all persons who enjoy protection under the Constitution. At a bare minimum. And if one follows the line of reasoning in the Lupin article, it is owed, as it were, to humanity, but that might seem a vague concept. But the truth is that is the ambit of what is said.
In effect, Mr. Unterhalter, do you then say that we should construe the words, the rules of customary international law in Section 4.1a of the Immunity Act as meaning the rules of customary international law that are law in the Republic by virtue of Section 232, and indeed, and also law by virtue of the provisions of Section 231 of the Constitution, where international agreements and so on have become part of the law of this country?
So we say it introduces a limiting principle which is of constitutional origin as to why the more expansive and absolutist stance that is taken by the government in its submissions to this court cannot be correct, because the Constitution itself has certain overriding values and certain duties that rest on the state in respect of these kinds of crimes. And for that reason, the sort of immunity that is suggested is inconsistent with the Constitution, and one must give a constitutional reading to 4.1a. And the constitutionally compliant interpretation is that the kinds of absolutist immunities don't exist if it is to be read in a fashion compliant with the Constitution.
But following up on what I asked you, if that's correct, then South Africa's obligations under the Rome Statute and by the Implementation Act are part of the rules of customary international law under 2314 and 232, yes, and therefore under 4.1a, and that immediately must qualify the immunities and privileges.
Yes. So there are two sources of qualification. The one is the international law, which is part of our law, and the rights in the Bill of Rights, which of course is part of our fundamental law, and the duties that rest on the state in respect of the duty to suppress. And taking all of this together, it provides a limiting framework that derives from the Constitution as to how you then engage in the reading of Section 4.1a. And that's the central thrust of our interpretive argument. We suggest that, sorry, just
are you suggesting that there are these sort of overarching principles in terms of our Constitution which should then inform the interpretive exercise?
Yes, indeed, absolutely, and are required to inform the interpretive exercise, because all statutory interpretation is informed and coloured by the Constitution and the rights and obligations to which it gives rise.
And, well, I suppose the second leg is, if you adopt that approach, then it perforce operates to, well, it serves a limiting function.
Yes, yes. And the consequence of that is that the reconciliation of the Immunities Act with the Implementation Act becomes much clearer, because there's a self-limiting principle in the Immunities Act, and consequently it reads perfectly coherently, as our learned friend Mr. Trengove was explaining, with the provisions that you find in the Implementation Act. And there's no question of implied repeal or trumping or matters of this kind. They read as a coherent whole. And we would submit to the court that that is an interpretive exercise that permits of a reconciliation without having to have regard to these doctrines of trumping or implied repeal and the like. And much of this was again said at paragraph 80 of the torture case, where it is said our country's international and domestic law commitments must be honoured. We cannot be seen to be tolerant of impunity for alleged torturers, read here, international crimes. We must take up our rightful place in the community of nations with its concomitant obligations. We dare not be a safe haven for those who commit crimes against humanity. Now, the reason that...
How then, if South Africa wishes to play a role in bringing to an end these kinds of appalling situations in a country, let us call it X rather than Sudan or anywhere else, there is a need then, as we see, to have conferences, to meet, to negotiate, etc. How does South Africa go about doing that if it wants, for example, to bring the warring parties to this country to set them round a table and debate matters? How does it do that if at the same time it's obliged possibly to arrest everybody around that table? Is there a mechanism? Can it use, for example, Section 7.2 of the Immunities Act or something of that sort? Does it get a dispensation from the ICC?
There would have to be some species of agreement that was sufficiently encompassing and consensually arrived at, that would probably have to get the blessing of the ICC in order to, for that very special purpose, to allow for a peace conference of that kind to take place.
Could it be the ICC or the Security Council?
Well, it might be the Security Council in the sense that in this instance they referred the matter specifically to the ICC. No doubt they could qualify the resolution in such a way as to permit of a carve-out. And one could see the same thing happening potentially in Syria and other in other conflict areas. But
I'm not sure that we have to be too concerned about how to go about making peace. What we're concerned with is how to ensure that somebody who steps on South African territory is brought to book.
Indeed, and that's why from in our understanding of this, our Constitution permits of this reconciliation. Could I just make two supplements?
The agreement that was entered into between the government and the AU was not intended to in any way deal with peacemaking.
It was diplomatic business as usual. So even if it could be thought that there could be a carve-out for very special purposes, probably sanctioned by the Security Council, that nowhere that doesn't approach the facts in this case. What does, however, is the fact that the second warrant that was issued, which is to be found at page 193 of the papers, in its terms, I beg your pardon, it's in respect of the warrant that was the application for the warrant, of the second warrant.
It's 193 of the application for leave.
I'm sorry, I'm told it's in the application papers. Yes. That it specifically references the fact that that the fact that there might be a continuation. It says, and he will not continue with the commission of the above-mentioned crimes. And we submit that the significance of the terms of the second warrant, which deals specifically with genocide, is that if one is thinking about what the ongoing duties of the state would be, they are in respect of a warrant which signals the risk that the question of genocide is not something just of the past, though that wouldn't in any way dilute the duty, but because of this risk of it carrying on, there is a very clear risk, and there's a very clear triggering of the duties that we have referenced in our heads in respect of the Docket case and the authorities that they in turn referenced. So we submit, therefore, that there is a clear case here of a duty to act, a duty to suppress, and that, seen in that context, one will interpret the relevant provisions of Section 4.1. If I could use...
Mr. Hilton, aren't you raising those words in the warrant a little further than is justified? As lawyers are wont to do, if you have a look at Article 58.1b, all that is a recitation of what is in 58.1b.
It is so, but presumably it was specifically included because it was thought to be of application.
Well, probably
it may have been simply
it's in every warrant that they ever issue.
Yes. It may well be that happens as a matter of form. I don't know. But certainly reading the text of the warrant as it stands, it apprehends a future risk. It doesn't only reference a past role. Could I just very briefly deal with one point that is raised by the government on the principle of subsidiarity? We submit that principle has absolutely no application in a context where one is applying an interpretation of legislation. In other words, the duty that courts have to interpret all legislation in the light of the Constitution and its content is not a question of subsidiarity, that one has somehow to have regard to a piece of legislation. That would become a circular argument. The requirement to have regard to the Constitution is simply what 242 requires, and when 232 requires, and when one applies it, one is simply implying the interpretive mandate that courts have to interpret legislation in the light of the Constitution. It doesn't engage the doctrine of subsidiarity, which would be in circumstances where, for example, one right cannot be directly accessed by way of the Constitution, but must reference a statute, or one duty cannot be carried out because there is some other statute which takes precedence. This isn't a question of precedence or priority. It is simply a question of primacy, and the primacy is the interpretive mandate of courts in respect of the Constitution and how to interpret statutes. So we do submit that subsidiarity is a distraction in the context of the interpretive debate. Could I come lastly to the question which has been referenced by a number of parties, but just in respect of waiver under Section 8 of the Act. We submit that there is very considerable importance to be attached to what the Constitutional Court determined in the Fick case, which we have referenced in our heads of argument. We say that because in the Fick case, it was found that there was an express waiver that arose by reason of the fact that under the tribunal protocol, there was a requirement upon state parties to give effect to the judgments in that case of the tribunal concerning simply an order for costs in that case. And it was said that when Zimbabwe had acceded to the protocol, it was in turn acceding to the fact that South Africa had obligations to enforce and carry out the decisions of the tribunal. And the court in FIC found that that amounted to an express waiver, because there was no other way of understanding what Zimbabwe's accession meant other than that it was waiving any sovereign immunity in respect of the execution duties that South Africa had under the protocol.
So that would be relevant insofar as accession to the Genocide Convention is concerned.
Exactly.
But insofar as the Security Council resolution is concerned, there's no waiver there, but there's a removal. No. There is a removal of immunity by the Security Council.
We want to reference specifically the Genocide Convention because we say there is very little to distinguish the way in which FIC dealt with the question of express waiver arising from the tribunal protocols and what one reads in the Genocide Convention. And if I could just very briefly take you to the language of the convention, in Article 4, it says, persons committing genocide or any of the other acts enumerated in Article 3 shall be punished whether they are constitutionally responsible rulers, public officials, or private individuals. And then Article 6 in turn references the fact that persons charged with genocide or any of the other acts shall be tried by a competent tribunal of the state in the territory or by such international penal tribunal as may have jurisdiction. Now here the ICC falls into that category. The importance of the language in Article 4 is that it goes to the very matter that our learned friend said was a sacrosanct part of immunity, which is personal immunity. It speaks to persons who are constitutionally responsible rulers. And we submit that that provision makes it plain that under the Genocide Convention there is there can be no immunity, personal immunity, let alone functional immunity, in respect of crimes of this kind. Now, we are fortified in that view by the academic writings which have been referenced, I believe, by Mr. Brickhill in his heads of argument. But Professor Slater, S-L-U-I-T-E-R, it is in the PJI's bundle of authorities, and particularly the passage at page 940. And if I could just read it to you. What he says is, in my view, the question of head of state immunity for al-Bashir loses relevance when the arrest is also grounded in treaty relations between the arresting state and Sudan, namely Article 6 of the Genocide Convention. The particular provision obliges a contracting party to the convention to ensure a trial at the ICC of a person charged with genocide. There is no exception of immunity set out in the Genocide Convention. Article 6, it can be said, applies to all persons charged with genocide. This interpretation also follows logically from Article 4, and then it references the language in Article 4 that I have read to the court. So the academic article here is making the very point which is made in FIC, which is that South Africa has an obligation to arrest for the purposes of discharging its obligations under the treaty. And the waiver arises, and in this circumstance, because the Sudan itself has acceded to the Genocide Convention, and consequently the waiver arises, and there can be no suggestion that Sudan and its head of state is able to claim immunity. So we submit that that is the relevant, useful academic commentary on this point. Our learned friends for government have referenced other authorities, and one in particular that they rely upon is that of Professor Broomhall. We will supply the court with the relevant passages of this academic work, but the relevant passage that our learned friends rely upon is actually, which suggests that immunity continues in respect of personal immunity, even if it doesn't arise in respect of functional immunity, is a reference to the Geneva Convention and not to the Genocide Convention. And that you will see at page 143, where the author says, this would occur where the requested state and the third state are both parties to the Geneva Convention or the Conventions Against Torture. It doesn't reference the Genocide Convention at all. And in further passages from this text, when the question is raised as to whether this differentiation between functional immunity and personal immunity makes sense, the author says, well, he thinks that this patchwork of immunity, sometimes one applying and the other not, would give rise to some degree of incoherence in international law. And so there is, even in Professor Broomhall's position, a degree of equivocation as to the absolutist stance that is suggested and attributed to him by the government in these proceedings. Could I then finally, and just taking up a matter that Justice Majid raised with my learned friend for the government, and that is just the passage in the House of Lords decision in Pinochet 3, where Lord Phillips, in his speech, and it is at page 289 of the judgment, made the following clear. He said, where states by convention agree that their national courts will have jurisdiction on a universal basis in respect of an international crime, such agreement cannot implicitly remove immunities, ratione personae, that exist under international law. Such immunities can only be removed by express agreement or waiver. Such an agreement was incorporated in the Convention on the Prevention and Suppression of the Crime of Genocide, which provides persons committing genocide or any other acts enumerated in Article 3 shall be punished, whether they are constitutionally responsible readers, and I've referenced the language of Article 4. So there appears to be, at least in this speech, a recognition of the very point that we are seeking to urge upon this court, which is that the accession of Sudan to the Convention gives rise to a waiver in respect of personal immunity, and that has been recognized, at least in the speech of Lord Phillips, at the passage that I've indicated at page 289 between the letters D to E. Just finally, on one formal technical question under Section 8 of the Immunities Act, Sudan has acceded to the Genocide Convention. And the consequence of such accession is that that as the Convention itself indicates in Article 11, instruments of accession shall be deposited with the Secretary General of the United Nations. Well, you can only have an instrument that is deposited if it is in writing. And so I don't think there can be any question but that Sudan's accession is in writing. It is, if the force of our argument is correct, which is that it is tantamount to an upliftment of any personal immunity. It means that there has been a waiver as contemplated in Section 8, and for that reason also, the immunity that is claimed by the government cannot stand. Those are our submissions.
Thank you.
As the court pleases.
Do you want to perhaps rearrange seating? I think it might assist Mr. Malindi. Yes, Mr. Malindi, you're going to have to persuade us to admit you as an amicus, as well as, well, which entails giving reasons as to why your arguments are novel and helpful, as well as make the arguments that you have made in your heads.
Thank you, Justice Lewis. Justice Lewis has indicated we will start by moving our application for admission as amicus and then address the one issue that we asked to address to the court. My learned friend and I represent the African Center for Justice and the International Refugee Rights Initiative, which seek leave to be admitted as amicus curiae in these proceedings in order to make submissions that we believe shall be of value to this court to determine the issue in dispute between the parties. These two organizations, historically, at least the African Center for Justice and Peace, historically resided and was based in Sudan until they were displaced by the activities or some of the activities of President al-Bashir, which are a subject of this hearing today. The center is now based in Kampala. The International Refugee Rights Initiative is based in the United States, and it is similarly an organization that seeks to ensure that violations of human rights are not committed with impunity in Africa. The submission that the two organizations wish to make is in addition to the South African Legal Center argument, and it is this: Sudan is bound and is under the obligation to provide for the right to an effective remedy under treaty law that Sudan is a party to. The International Covenant on Civil and Political Rights, African Charter on Human Rights, on Human and People's Rights, and the Human Rights Committee's General Comment number 31 set out the content of this right and Sudan's obligations thereunder. It will be submitted, therefore, that because Sudan is a party to these conventions, this norm of international law applies to the facts of this case. The norm...
Mr. Malindi, I'm
as the court
sorry to
pleases.
interrupt you, but my difficulty with your application is that in the application itself, the approach taken, as I understood it, was that your clients wished to place evidence before this court, that it was highly material, that the evidence should be put before the court, and so on, but that insofar as the law was concerned, you were content to rest, and this was said in paragraph 17 of the founding affidavit at page 7, you were content to rest with the arguments to be advanced by SALC. Now, the attempt to lead further evidence having failed, on what basis are you here advancing submissions, not only submissions, but asking us to read 750 pages of additional documents which were delivered a day or so ago?
Justice Malcolm, as I understand, we have not been admitted to lead further evidence.
It is usual to address the judges by their surnames rather than their first names, Mr. Malindi. It's Justice Wallace.
I thought that's what I said, my lord. I understand I did not.
These things can happen.
Justice Wallace, my understanding is that our application to lead further evidence was dismissed, and we've been confined to argue
You're confined
only...
to legal argument that is useful and helpful to the particular set of facts that are before us. So you're confined to the record. And while, of course, I think there must be great sympathy with the argument that you make, which is that people are entitled to remedies, they're entitled to effective remedies when they are the victims of crimes against humanity, international crimes. I'm not sure how it impinges upon the argument of the government, or for that matter, the litigation centre that the government was obliged to conform with its obligations under the Implementation Act and under the Constitution, and in a simple matter of its duty to surrender under Section 10.9.
Thank you, Justice Lewis. Justice Lewis, as we understood, and Justice Wallace, the applicants for amicus here totally associate themselves with the argument of the legal center, which is based on the interpretive processes that the court has already had between the parties.
What additional submission, legal submission, do you have that is germane to the issue between the parties?
The legal submission that we wish to make, Justice Lewis, is that because Sudan has bound itself to the conventions that we have referred to, that is yet another way outside of the self-interpretative way to the ICC that we say it has bound itself to be held to discharging human rights and affording victims of human rights effective remedies in the forms of investigations, arrests where applicable, prosecutions, and sanctions were applicable. And the only way that Sudan may be held responsible and to adhere to those undertakings under those treaties remains the only viable legal avenue, which is the ICC.
So you're saying in addition to the Constitution and in addition to the Implementation Act, we should invoke the various charters and treaties to which Sudan is a party in order to ensure that South Africa commits to its international obligation to surrender the President of Sudan if and when he appears on South African territory.
Indeed so, Justice Lewis.
Is there anything else that...
Justice Lewis, the basis of our argument is set out in the heads of arguments, which are pretty short.
Yes.
And paragraphs 16 up to 23 deal very much with the cases that we have referred to. If the court has received our 2 bundles of authorities.
We received them yesterday, Mr.
Yes.
Lindy, and as I explained in chambers, we certainly haven't had the opportunity to read that which we haven't already read.
The parts that we refer to are very narrow, as Justice Lewis can see. I was going to refer to a few excerpts, so it will not be necessary to traverse through the 2 diverged files. The references are set out clearly in our heads of argument, and we submit that the court will not be subjected to reading more than 20 pages of what we have referred to.
Thank you.
Justice Lewis, may I just confer with my junior who has just forwarded me a note?
Of course.
Justice Lewis, I wasn't certain if that is an indication that the court is satisfied that the court will refer to my heads or whether I should proceed.
No, we will refer to your heads, but that doesn't mean that we'll necessarily admit you. That is something on which we will have to confer after the hearing. Yes. But we're happy simply to refer to your heads.
As the court please.
Thank you.
Justice Lewis, I have already indicated what the organizations are,
Yes.
and to emphasize that their role is that of being the voice of the people of Sudan in these proceedings. With reference to the International Convention, we refer to Article 2, brackets 3, which
Sorry, which international convention?
International Convention on International Convention on Civil and Political Rights. And Article 2, brackets 3, states that each state party to the present covenant undertakes to ensure that any person whose rights and freedoms as are herein recognized are violated should have an effective remedy. And it is an article that is referred to in the general comment of the United Nations Human Rights Committee, General Comment number 31, which I beg leave to read in particular at Articles 15 to 16. And Articles 15 to 16 in part read as follows. Article 2, paragraph 3 of the International Covenant, which I've already referred to, requires that in addition to effective protection of covenant rights, states parties must ensure that individuals also have accessible and effective remedies to indicate those rights. And further down it reads that administrative mechanisms are particularly required to give effect to the general obligation to investigate allegations of violations promptly, thoroughly, and effectively through independent and impartial bodies. And item 16 reads, Article 2, paragraph 3 requires that states parties make reparation to individuals whose covenant rights have been violated. Without reparation to individuals whose covenant rights have been violated, the obligation to provide an effective remedy, which is central to the efficacy of Article 2, paragraph 3, is not discharged. So I submit your Justice Lewis that these general comments made on in May 2004 clarify beyond doubt the provisions of clause 2, brackets 3 of the convention, and at the top of clause 4 of the comment, it is stated that the obligations of the covenant in general and Article 2 in particular are binding on every state party as a whole. It is our submission therefore, that this is a binding provision and that it is a way, in addition to the interpretative path to the ICC, through which President al-Bashir should be subjected to the jurisdiction of the ICC. It was found in the Africa-American Court of Human Rights in the case of Velasquez Rodriguez of 29 July 1988, and I shall briefly refer to what was stated in...
Have you referred to that in your head?
We have, my lady.
Yes.
Is that footnote 9?
Yes, it is.
Is that footnote 9? In your head?
That is so. That is so. Justice Code.
Yes.
Yes, I think perhaps I misunderstood you, Mr. Milindi, when you suggested that if we had your heads, that was sufficient to enable us to follow your argument and to assess it. Was I incorrect?
That is correct, Justice Lewis, that the heads provide a summary, most probably a more eloquent summary of what I am saying at the moment.
Yes, would you be content then to leave it to us to read the heads in order to make the determination both as to whether to admit the African Centre for Justice and the International Refugee Rights Initiative to be admitted as amici and to take into account your arguments?
Yes, the court pleases, my lady. Justice Lewis. Justice Lewis, the subject that I was dealing with, which is to the effect of the effective remedy under international law, appears from page 3, which is from paragraph 6 onwards. And we refer to some of the instruments that we submit are applicable, and when I reverted to my heads was when I was addressing myself from paragraph 16 onwards with particular reference to cases that we have referred to.
We will have regard to that.
Sure.
But are there any further submissions that you need to make, or are they all covered in the heads?
Justice Lewis, I think that is the total submissions that we will make under the circumstances, and I will make closing remarks after conferring with my junior with the leave of the court.
Yes.
And finally, Justice Lewis, on page 9, paragraphs 24 to 27, we make the submission that we say we associate ourselves, which is the interpretative process in terms of the Constitution, and to the effect that the Rome Statute binds the government to deliver President al-Bashir, as has been ruled by our courts already.
Thank you, Mr. Milindi. We're indebted to you. Yes, Mr. Brickhill, the same principles apply to you.
As it please the court. May it please the court. We're alive to the principles that govern our participation. We seek admission on behalf of two amici curiae, the Peace and Justice Initiative and the Centre for Human Rights. The Peace and Justice Initiative is a non-governmental organization based in The Hague. Its members consist of current and former members of the very international tribunals whose decisions have been debated in today's hearing. Its purpose, its reason for existence, is to enhance the capacity of national jurisdictions, such as our own, to investigate and prosecute international crimes. This case is its reason for existence, and it has a particular expertise in this area of law. I might indicate to the court that unusually perhaps for a client amicus, it has been substantively engaged in the preparation of the argument to an unusual degree. So our submissions, to the extent that they may or may not assist the court, are informed by the Peace and Justice Initiative's own expertise. The second hopeful amicus, aspirant amicus, is the Centre for Human Rights, which is a well-known institute of the University of Pretoria's law faculty. It has a particular expertise in the African regional system, and is perhaps one of the leading authorities academically on the evolution of that system, the African regional system. Our application remains opposed, as we understand it. The application was made expeditiously. A consent letter was delivered on the 12th of January, and the application followed 9 days later on the 21st of January. We submit that we acted within the time periods. We accept, though, Justice Lewis and members of the court, that the time pressure within which the proceedings have been conducted has impacted on the conduct of all of the parties. It has impacted on our ability to be of assistance to the court. It has impacted on certainly the time that the court has had to process our submissions and the material that supports them.
Yes, no, we appreciate that, and we are all affected by it. But perhaps you could just tell us what argument you're going to make that is novel, different to that of the litigation centres, that will help us in the interpretive exercise.
We submit with respect that that is also the key issue in our admission. Although there have been other objections, it's the newness or novelty of our submissions that is the main basis on which government opposes our admission. We submit, milady, that in any case that turns on the interpretation of provisions of a statute or a treaty, it is inevitable that an amicus will find itself addressing submissions to the very same provisions that have been debated at length by the parties.
But that's the point of excluding people who have nothing to add to that which both of the parties have to say.
With respect, milady, we submit that we do have something discrete to say on each of the points that we address.
Yes.
We address 5 targeted submissions, 5 issues, in our 10-page written submissions. The first is the jus cogens nature of the crimes and the international nature of the International Criminal Court, the effect of those two principles. My learned friend, Mr. Unterhalter, for the admitted amicus, has addressed the nature of international crimes. They've dealt with those at some length in their written submissions, but no party has squarely addressed the jus cogens nature of the specific crimes with which President al-Bashir is charged. These jus cogens norms constitute peremptory norms of international customary law. They take precedence over any other principle of international customary law or any other treaty. Significantly, no derogation is permitted from a jus cogens norm, and where a crime constitutes a jus cogens norm, the prohibition embodied in that crime is absolute. The relevant crimes against humanity that here constitute jus cogens norms are genocide, crimes against humanity, which include torture, and war crimes. And the ICTY, the Tribunal for Former Yugoslavia, in the Furunzija judgment, has confirmed that universal jurisdiction attaches to these offences, these jus cogens offences. Any state may prosecute.
What does it mean by that?
Justice Wallace, as we understand the practical import is that any state may prosecute domestically within its national court for the commission of a jus cogens crime.
That's the same principle that's applied in respect of piracy, dating back for several hundred years. So where does this take us? The argument before us is that Section 4 of the Immunities Act gave President al-Bashir immunity. That's the issue before us.
Justice Wallace, with respect, the impact relates to the arrest warrant judgment on which reliance has been placed by government, and the subsequent Taylor decision of the Special Court of Sierra Leone on which we've relied in our written submissions. an issue not yet addressed squarely by any of the parties. In our submission, Justice Wallace, the import of the arrest warrant judgment, this arose in debate earlier, is that immunity persists before national courts, but the Taylor decision, the Special Court of Sierra Leone, the appeals chamber, which based its decision on the very same arrest warrant decision, held that such immunity will not carry through before an international tribunal such as the ICC. That exception was left open on the language of the arrest warrant case itself, and we submit that Taylor further confirms that principle under international law. The court in Taylor identified two factors, twin elements, that effectively abrogate immunity in such proceedings. The first is the nature of the offence, and the second is the nature of the tribunal. These two factors are mentioned at paragraph 49 of the Taylor decision. And it's there with respect, Justice Wallace.
Where the Taylor decision is in this bundle of
the relevant paragraph appears at page 762 of our authorities bundle, Justice Wallace.
762.
As I see it, Mr. Brickhill, these arguments simply bring further authority to the argument already made by the Litigation Centre, myself, and the argument made by the Helen Sisman Foundation. There are a number of cases and instruments that bolster the argument that the Rome Statute and the Implementation Act have created the exception.
Indeed, so, with respect to the clarifying position, arrest warrant left it open in paragraph 69, left open the exception.
Has changed, the law has moved on since 2002.
Justice Minister.
The Rome Statute has come into force. The Implementation Act has been enacted. So the arrest warrant judgment, no matter its quality or the criticism of it, has very limited application now.
Indeed so, Justice Wallace. And we've simply pointed to the Taylor decision as one subsequent indication that is so. Yes. And of the two factors that will inform the determination whether any immunity can persist before an international tribunal. And they are the nature of the offence and the nature of the tribunal as an international tribunal. Where the crime is a jus cogens crime, we would submit that there's an emphatic basis to resist any space for immunity. So it is really a gloss on submissions that have been made, but with respect, different.
As I see it, I mean, one welcomes all the assistance that you can get, but as I see your heads, this jus cogens argument is just an expansion of what Mr. Trenger has already argued and expanded upon by Mr. Unterhalter. And the same goes for the other two main topics that you address, is the resolution and the genocide convention. I mean, it's very helpful to collate as many authorities as possible, but at the end of the day, it's a very narrow, the crux of the matter is quite narrow.
With respect, Justice Majid,
so what do you bring new to the table? I mean,
if I may turn to the Security Council resolution, and I'll limit my submissions precisely to those aspects that have not been mentioned.
Can you just, before you do that, just remind us, because you've only given us an extract from the Taylor judgment, precisely what were the circumstances in which Mr. Charles Taylor found himself before the Special Tribunal, factually?
Justice Wallace, it is addressed in a footnote to our heads of argument. The upshot was that he remained incumbent head of state at the material time when an application to annul the charges was brought. So at all times up to that point, when an application to annul was made, Charles Taylor remained incumbent head of state. There were earlier events involving attempts to secure his presence through Ghana, but the relevant fact is that he remained incumbent head of state.
My understanding of it was that Mr. Taylor was only brought before the tribunal after he had ceased to be the head of state, and that the case of Taylor deals with the entitlement of the tribunal, which was established, to prepare an indictment. And this application arose because Liberia and Mr. Taylor applied for that indictment effectively to be quashed. Am I wrong in that?
Justice Wallace, that does accord with our understanding. But
so all it was concerned with is it legitimate for there to be a prosecution of someone who's a head of state when the tribunal's constituting document, the statute, said that the official position of any accused person shall not relieve such a person of criminal responsibility nor mitigate punishment. It had nothing to do with Mr. Taylor being arrested by some country and brought before the tribunal. Is that right?
Indeed, Justice Wallace, but it did have regard to, it did have a bearing on his liability and whether the basis of his office could be used to invoke immunity. Justice Majid, if I could then turn to the Security Council resolution, we do submit that what we have to say is distinct. The question arose earlier on what basis the Security Council resolution is binding on Sudan. And the answer was given by my learned friend, Mr. Trengo, with reference to Articles 48 and 49 of the Charter. We would refer further to Article 25 of the United Nations Charter, which provides in terms that Security Council decisions bind member states. We would submit that that's the primary basis on which Resolution 1593 binds Sudan. We would refer further to Article 103, which provides, and that is included in the extract that the SALC respondents have now handed up. Article 103 provides that charter obligations prevail over obligations under other treaties. So for completeness, we would mention those two articles. As concerns the effect of the resolution, we do make a submission with respect to a subtle difference, a difference of nuance as to its effect. The resolution did not make Sudan a party to the ICC statute, but rendered it akin to a party. It rendered the ICC statute applicable to Sudan, notwithstanding the fact that it is not a party, and it did so to the extent of the Security Council resolution. We refer in our heads of argument to Libya as an example of a previous incidence of such practice, where a Security Council referral placed Libya in the identical position of being akin to a party to the ICC statute. What then is the scope of the application of the statute, and in particular, immunity under the ICC statute? Our submission in this regard is that the resolution, the Security Council resolution, on its terms, did limit the application of the ICC statute in at least two respects, but not in respect of immunity. It did so in paragraphs 6 and 7 of the resolution. Paragraph 6 relates to a question of jurisdiction, and paragraph 7 relates to funding of proceedings flowing from the referral, proceedings in the ICC. And in both respects, the resolution in paragraph 6 and 7 qualified what would otherwise have been the position under the ICC statute. So what can one draw from this? One draws from this that the Security Council was alive to the provisions of the ICC statute and deliberately qualified two of those provisions in respect of the Sudan referral. It did not do so with respect in relation to immunity and Article 27. And we would submit that that is significant. The effect of it is that the referral carried with it Article 27 and its impact on immunity of incumbent heads of state.
Mr. Brickhill, just at a factual level, one of my problems with this construction of the Security Council resolution arises from factual matters. For example, that it is known that President al-Bashir has visited China, which is a permanent member of the Security Council, and presumably a party to this resolution. And I don't know whether he was welcomed in the Great Hall, but he certainly wasn't shut up in jail and packed off to The Hague. Is sauce for the Chinese goose not sauce for the South African gander?
With respect not, Justice Wallace, the resolution has an impact on the obligations of the two states that matter in this case. On Sudan, rendering it akin to a party, and on South Africa, in our submission.
Well, didn't it have any effect on China, which presumably, as a member of the Security Council, was a party to the resolution, because if it had voted against it, that would have been a veto?
Well, it should have acted differently. It didn't.
Justice Wallace.
Just as a matter of fact.
Indeed so, Justice Lewis. China would be covered by that part of the resolution that urges states to cooperate.
I'm not sure we want to use
China
as the standard, as the flag bearer.
Indeed, Justice Bond. With respect, Justice Wallace, that issue is a difficult one. What is the obligation of China under the resolution being urged to cooperate, not a party to the ICC statute? It's not a question that this court is required to determine. And with respect, it doesn't follow that South Africa is in the equivalent position, or that China's conduct has a bearing on our obligations.
Or that China's conduct should be condoned.
Indeed so, Justice Lewis. The third theme that we address is the Genocide Convention. I shan't repeat a single word that's been covered by the other parties. Their focus, my learned friend Mr. Trengove and Mr. Unterholter both focused on the immunity consequences of the Genocide Convention under Article 3 and Article 4. And Mr. Unterholter has already dealt with the issue of the Pinochet judgment, which Justice Majid raised earlier in relation to a submission in our heads of argument. Those issues have been dealt with. Our submission relates to a further obligation flowing from the Genocide Convention, to which both South Africa and Sudan are parties. And it's an obligation flowing from Article 6, which requires all states parties to cooperate effectively. The court in the Genocide Convention judgment, which we cite, it appears at page 557 of the bundle, and the relevant paragraph is 443, held that this obligation to cooperate includes an obligation on states parties to arrest alleged perpetrators of genocide, even if they are from another state, are alleged to have committed genocide in another state, and have no other link with the state with which they happen to be in. That appears from paragraph 443 of the Genocide Convention judgment, which has not yet been referred to by any party. In that paragraph, the tribunal held as follows. In fact, it's the ICJ, it's the court. At page 557 of our bundle, paragraph 443 of the judgment, it is thus the obligation for states parties to cooperate with the International Penal Tribunal mentioned in the above provision. That's a reference to the ICC. For it is certain that once such a court has been established, Article 6 obliges the contracting parties, which shall have accepted its jurisdiction, to cooperate with it, which implies that they will arrest persons accused of genocide who are in their territory, even if the crime of which they are accused was committed outside it, and failing prosecution of them in the parties' own courts, that they will hand them over for trial by the competent international tribunal. The upshot of this obligation arising from Article 6 of the Genocide Convention is that South Africa bears an independent obligation, quite apart from the ICC statute, to arrest and hand over President al-Bashir. And the ICC's jurisdiction in respect of those charges has been triggered by the UN Security Council's resolution. Two final issues to address briefly. I'll attempt to move through them quickly.
Is this the Articles 27 and 98?
Indeed so. My final submission is very brief on access to justice. Articles 27 and 98 are perhaps the hub of, or the nub of the issue internationally, under international law. As we understand it, government opposes our reliance on some of the authorities that we cite in our heads of argument here, which relate to drafting history, the background to the ICC statute, on the basis that that material constitutes new evidence, and that we were required to bring an application for its admission. We submit that that is, with respect, not so. The authorities on which we rely fall into two categories. The first are academic authorities, and they include in particular the article by Kreb and Prost, which discusses the text and the drafting history. In this regard, government itself relies on another article by Prost at footnote 120, which itself talks about, in the relied upon section, the intention of the drafters of the ICC statute. We submit that there's nothing controversial about relying on academic commentators who are alive to drafting history. The second body of authorities on which we rely are the reports of committees and specialist bodies that played a role in the birth of the ICC statute. In this regard...
The ICC statute or the Rome statute?
The Rome statute,
Yes.
with respect, Justice Lewis. The statute of the ICC.
Do we need to go there, given that the equivalent of Section 98 is not embodied in the ICC statute? It might be a difficulty generally in interpreting the Rome statute, but we don't appear to have the same difficulty.
That may well be so, Justice Lewis. Commentators across the world salivate at the prospect of this court considering the issue. That, of course, is no reason to venture into the territory. But it did seem to us that in the way that the issues were formulated, the impact of Article 98 may arise. So we address it in that alternative eventuality. We submit that this court is permitted to have regard to the reports of the committees, the preparatory committee, the specialist rapporteur that contributed to the birth of the Rome Statute. This is so because of the nature of international law. International law is not born in the same way that domestic legislation is, where one has regard to Hansard debates. International law has its birth in soft law principles, which ratchet towards normativity over time. And those soft law principles are themselves international law. Courts may have regard to them, and our courts do so all the time. What then does the drafting history tell us, and what is the answer to the Article 2798 conundrum? Well, they tell us that states came to the table with different views, that different participants in the debate had different views, that there was a body of opinion that suggested that personal immunity had been substantially or entirely eroded. But there was also a feeling embodied in the Singapore proposal, which we refer to in our heads of argument, that not enough time had been given to consider this difficult issue. And so a compromise solution was required. And that compromise in Article 98 has been described as a complex one, which requires, importantly, case-by-case determination by the ICC itself whether there is immunity. And that's the upshot of our submission on this score. That the scheme of the Rome Statute is that it is for the ICC to determine whether immunity under Article 98 arises on some basis. And this is also reflected in a rule of procedure of the ICC to which we refer, which none of the other parties have mentioned. It's Rule 195, which expressly requires states to place information before the ICC relating to any matter arising under Article 98. So it envisages a process where states place information before the ICC, if necessary, bring an application to discontinue charges, but not for states to take that difficult decision into their own hands. In this case, the ICC, as we know, has ruled that immunity doesn't apply.
Well, the ICC has ruled, and Article 27 is embodied in the Act.
Indeed so.
Yes.
We submit that the scheme of the Rome Statute leaves that decision to the ICC, even if it were not, as Justice Lewis has pointed out, our Act doesn't leave the Article 98 escape valve. Our final submission relates to access to justice. And we really only want to mention one authority here because we do submit that it is significant to the evolution of the law in this area. And it's the Malabo Protocol. Our submissions in this regard flow from the submissions of my learned friend Mr. Malindi on the need for an effective remedy and victims' rights. We submit that there is no realistic prospect at present of a prosecution either in Sudan or before an African regional court. And we point to the Malabo Protocol, which does exist, but it exists with 0 ratifications, requiring 15 ratifications to bring it into effect. It will create a separate chamber of the African Court of Justice and Human Rights with criminal jurisdiction. It is the envisaged African solution, but it does not yet exist. And in any event, even once the sufficient ratifications have been received, it will not be a possible forum for the prosecution of President al-Bashir for two reasons. And we refer to the two articles of the protocol. The first is that it will have prospective jurisdiction only from the date on which it comes into force. And the second is that the Malabar Protocol in Article 46 does provide for immunity of incumbent heads of state. It does embody that immunity. We submit, therefore, that the ICC is the only realistic prospect for prosecution, and that South Africa playing its role in that regard does not involve a breach of state sovereignty, does not involve South Africa imposing its authority on another state. To the contrary, the elements of the jurisdiction to do so arise from the collective judgment of the international community. They are the jus cogens nature of the crimes, which are the highest in the hierarchy of international norms. The international nature of the tribunal and the UN Security Council's resolution, all of these embody collective judgment of the global community. Justice Lewis, we respectfully therefore seek the admission of our amici. We accept, as one must, that the prospects of an amicus impacting on the outcome of a case are always uncertain until the case unfolds. But the test is whether the submissions are novel, whether they're useful and relevant. We submit that they are, and that we've endeavoured to limit our submissions to things that have not been said by the parties. We've referred to this court's judgment in Jibai, where in paragraph 52, this court held that unreasonable opposition to an amicus submission application will warrant an order of costs in relation only to that admission application. This is ultimately a matter for the court's discretion, but with respect, we seek the costs of our admission application if admitted. Those are our submissions.
Thank you, Mr. Brook. Mr. Gauntlet, you have a lot to reply to.
Thank you.
But if you could limit.
I shall certainly seek to limit the, the ambit, or what we have to say, and to structure it as clearly as I can. Justice Lewis and members of the court, Justice Wallace put starkly into play in the debate the ultimate fork in the road which emerges depending on the court's outcome, the outcome of the case. And the court will do what it has to do pursuant to its duty. But the dilemma is sharply identified, and with respect correctly so, by Justice Wallace. There is, on the one hand, that great upsurge across the world in favor of universal jurisdiction against the idea that wicked people can roam the world, go shopping, have medical appointments, make peace, not make peace, be belabored, not be belabored about it. And on the other hand, the fact that if this court holds that the effect of the statutory provisions which are in dispute is that there is no immunity, temporary, vesting in a sitting head of state, then realistically this country cannot play host to international gatherings which are directed multilaterally to attempt to find solutions, where there are any such heads of state likely to attend. It will either have to withdraw from that function and withdraw from bilateral dealings as it has done of the kind that we've indicated in relation to the DRC, the Great Lakes region generally, even now Central African Republic, and the like, where there is any risk of an international warrant being forthcoming. And that may be a consequence of the needs of justice as the court sees it.
Government wishes to broker peace between Sudan and South Sudan and in Sudan, then they're welcome to go off to Sudan.
The consequence will be that there will certainly be a fundamental effect on the way things are done. arising from that. And that, as Justice Lewis and I indicated that already, the court may find that that is a consequence. But there is a reality which impinges, and that in the case of the Sudan and the Central African Republic and the past in Ivory Coast, what Justice Lewis put to me is simply not an option. Our ministers and presidents cannot go into war zones easily, and that is one of the reasons why it is necessary to do what this country has done. But what I do want to identify at the outset...
What has this country done insofar as Sudan is concerned in making peace there?
Justice Lewis, it's not on the papers, but if you would like me to go off the papers and go into some detail about what it's done, I could do so, but I don't really think... It has been, may I just say, an active protagonist of peace and achieving peace in Sudan as it has in relation to the other countries.
But the purpose of allowing President al-Bashir here was not to broker peace.
Justice Lewis, that point has been made once or twice. It was suggested that what one had was, I think, as our learned friend put it, I think it was Mr. Duplessis, run-of-the-mill or general diplomatic meeting. There is absolutely nothing to suggest that when the African Union was going to meet, it was not going to discuss its most pressing issues. I don't think any of us can say more because it's not a matter canvassed on the record.
It's not canvassed at all.
But to draw the inference, as is being put to me, that South Africa might perhaps have not been, as was put, I thought, perhaps rhetorically in the question by Justice Lewis, has not been actively involved in Sudan peacemaking, and that the AU meeting had nothing to do with it, we respectfully submit that it's a neutral factor to which we really don't know.
But it's not neutral for us to consider the implications of our decision on the capacity of the country to engage in these activities at some later stage. And as we all know, there were announcements today that peace efforts in Iran or Syria have had some success, but they've been conducted in Geneva because the people who are fighting in Sudan or Syria or anywhere else can't possibly get around a table in those countries.
With respect, it is so, and it is, if the president of Iran, after the years of enormously dangerous, on the brink nuclear conflict, has been able to go in recent weeks to Paris to meet with the president of France, it is precisely because what is being symbolized once again is the application of the very old rule that it's vital for international relations. And this underpins our argument, we say unrepentantly after everything you've heard, that there is nothing to show that international law, customary law, has evolved since 2002 or any other time to a position in which that principle is abrogated in its absoluteness as it applies to a sitting head of state. You can go against any other serving Sudanese minister or vice president or army officer that you can get your hands on, but you can't do it to the head of state or his envoy for that reason. We respectfully submit that that remains the position of international customary law. But that is, members of the court know that there are narrower questions before us. And ultimately the question is, which lies at the heart of the matter, is whether SALC is correct about the work it says that 10.9 and 10.5 do in the ICC Implementation Act in relation to Section 4, etc. of the Immunities Act. But before we get there, might I just dispose briefly, I hope, of some of the ancillary points which have arisen. They shouldn't be ancillary, but again, with well understood and well crafted advocacy, our learned friends for SALC did not start in the orthodox place about that boring topic of whether or not we should be given leave to appeal. It was, again, no inadvertence, because when members of the court put to our learned friend the questions of whether it was suggested, first of all, there was no argument against the number, I always get the name wrong, Nambatoni Technologies, Justice Wallace's judgment in this court, saying, never mind mootness, if they're compelling, as between parties, compelling other interests, the court will take the case. Not a word of an answer in that regard. And the inference is that the opposition and resistance has been not reasonable, and secondly, there is no reason why it was not articulated to you at the earliest possible stage that there had been a rethinking. There was a suggestion, an argument by a learned friend, that there was a rethinking which came about, but we showed page 218 of the record that on the same day as we were arguing for leave to appeal, and it was being said against us that leave should not be granted because it was moot, that on that same day SALC was saying it would carry on with the war in relation to the enforcement of the orders. So with great respect, it's no excuse for the situation then, and certainly not for the situation which prevailed through the practice note, through the heads of argument, no intimation of any kind prior to our learned friends rising to argue the matter. And in answer,
there is the indication that the principal reason for opposing is that there are no reasonable prospects of success, which is not inconsistent with SALC's attitude that it will continue to fight to.
But with respect, what made it such a strange position is that before the court below, the council were directed that that's not on the table, don't talk about that, prospects of success, from which there's only one inference to be drawn, we thought. The second aspect is that then SALC persists in the mootness argument. And even on the question of no reasonable prospects of success, there are times we respectfully submit where it has to be said in litigation that this is difficult, this is new. And how do we say that there is no reasonable prospect of success in relation to something which is so head-banging? But my point beyond that is, why weren't we told what the basis is? Why weren't you told what the basis is for the application for leave to appeal? One line in the practice note, one concluding paragraph. But may I just say that on this, you would know that in answer to Justice Lewis presiding, our learned friend, not offered, but in answer to her questions, presented the answers that, yes, as regards the first order, unless one can go the way which has been mooted or used in a different sense by Justice Wallace, about that the first order, the declaratory order, only refers to past conduct, that there's no other answer. And as regards the question of the standing warrant, our learned friend quite correctly ultimately said SALC has accepted that the second order is not moot. There is a gin trap out there for the President of the Sudan, and that makes this a live case. You heard me on the first point. I've submitted with great respect that it doesn't make it moot, that as at the time, how does a matter become moot? At the time between the making of the order on 16th June and the ultimate delivery of the judgment and leave to appeal on, I think, 16th September, nothing had changed. There was still the same finding squarely against the government of a very serious thing, which if it's right, it must stand, and that is that it has acted in breach of constitutional obligations. Of course, that is backward looking, but so are many orders that come before you. So we respectfully submit that there should have been an upfront, more direct answer on that. But let me turn to what really matters. And what really matters, we then submit, is this. You've heard two solutions today to the Section 4 versus Section 4 and Section 10 problem. The two solutions, and I'm going to do the unorthodox thing, it seems, of willfully starting with Section 4 of the First Act, and bang on the same point, briefly though, that it's critical to ask, what did Parliament do when it made the first Section 4? Because if it did X, then when the second statute came into operation 6 months later, what did that do to the ambit of the first provision? One answer against me may be that we are wrong when we say that nothing could be clearer than the ambit of the first provision in creating absolute personal immunity on a temporary basis as for the duration of the office. And I'll come to that in an attempt to call into aid the sub-provisions of Section 4.1 in a moment. But our learned friend, Mr. Trengove, delivered this answer. And he delivered it, and His Lordship Justice Ponnen, perhaps because of the radical nature of the answer, challenged it immediately or questioned it immediately. The postulate was this, that the Implementation Act amends the prior section to the extent of the inconsistency. And Justice Ponnen then intervened to say, no, but does one have to go that far? You have to talk about an amendment. And it does not want, and then as a matter of interpretation, is there an inconsistency? Which really goes back to the point which I believe Justice Lewis has been exploring from the outset. When you put the two statutes together, where's the inconsistency? But let's be clear about it, that SALC has argued before you today that it stands by what it is called the trumping language, the negating language, and you heard it articulated as being an amendment. It would have to be an implied amendment because we know there was no express amendment.
I didn't understand the argument to be that there was an amendment. I understood it to be that that Section 4 of the Implementation Act introduced an exception.
How, though? That is the critical question. And the critical, because when you have a provision...
Providing that in certain circumstances a head of state must be surrendered.
Yes. But you can only do so if you have a provision, Justice Lewis, which says that all taxpayers shall do X. It's absolute terms for the duration of their employment, as by way of parallel. And a later statute comes along and makes provision which it's contended to deal with some sort of carve-out for that, from all taxpayers, absolutely. Then the question is, how does it achieve it? And we respectfully say that this is the dilemma which our learned friends have circled around. They do have to say that what happened when you've got an absolute provision which is cut down in a particular way, that they can argue for an implied repeal is not a word they like, an implied amendment. We say that that is an argument which won't find favor with you, and the only one which may have legs is the one which Justice Ponnen was exploring and which Justice Lewis and others have also explored. And that is, but as a matter of interpretation, is that really so? And so what I would like to say in relation to Section 4 is where we part company so fundamentally, as the court knows, is the suggestion run most vigorously by HSF that the way you read Section 4 is that it's, 4.1, it's such immunities as, and then follows ABC. But it's not so, and it's not grammatical or other pedantry that makes us say so. If you look at the structure of the provision, it's making the absolutist statement in the first part of Section 4.1, which is not incongruous because, for the reasons we've argued to our own nausea, if not the courts, the rule of customary international law in relation to personal immunity of a head of state is that endures for as long as the king or the president is there. So there's nothing anomalous or absurd about the proposition. And then what happens, it says, and enjoys such privileges. It doesn't say a head of state, and this is the way it would run, shall enjoy such immunities and privileges as dash A, B, C. And it's such privileges. The immunity is specified, it's done with. It's done with grammatically and functionally. It's stated without qualification. And the privileges are then as heads of state enjoy, etc. And then follows, for example, in B, I know the word immunity comes into there, are provided for in any agreement entered into with a state or government whereby immunities and privileges are conferred upon such a head of state. Tax immunities are an example which come in there. There are other kinds of immunities which may arise, that you're not subjected to restrictions on how long you are in the country, etc. So that's what's so important, functionally and grammatically. 4.1 is saying, please read my lips. I am saying domestically for South Africa what we have known to be the position for hundreds of years. And so we say that the attempt to narrow down 4.1 in the way which has been argued does not fly. And it is for good reason that it's not an approach which has not seemingly commended itself particularly to SALC. Now, on Section 4, the question is, if we are right, and that is the position, what happens when the ICC Implementation Act comes into operation? Well, the position is that up to the day before, there is an absolute immunity for any and every head of state who finds himself or herself in South Africa. And by legal principle, and I hesitate to venture in particular, well, let me say this, it's a judgment in which His Lordship Mr. Justice Wallace had been counsel, called the Long Shan, 1998 1646. It's long, MVYU Long Shan Dry Bulk SA, 1998 1 SA 646, and the passage at 653C, stating the ordinary interpretive principle that one does not readily impute to the legislature an intention to impose liability for past conduct or events where no liability existed at the time, and here it comes, or to set at naught an immunity which existed at the time. It seems to be trite enough that if there's an immunity, you ask yourself, now, how do things work? If we write on the interpretation, in comes the new act. And we respectfully submit that the difficulty which arises in this regard is a postulate which Justice Lewis has put up for debate a number of times, and that is how significant it is that Article 98 of the treaty did not find its way into the Act. Well, it couldn't do it. I seem to have lost my treaty. I'm looking for the... No, I'm sorry, my statute. Here we are. If one goes to it, it couldn't do it, because 98 says the court may not proceed with a request, 1, and the court may not proceed with a request, 2. South African Parliament is not going to adopt a statute which says that the ICC court can't do something. It has said so. And the purpose then of the Implementation Act, we know through the long title, is to give domestic life to this and to its philosophy. And Article 98 is a clear mark-out at consensual international law level that do understand this. All those of you who join with us in this epic venture do know that we are respecting what is your obligations under international law existing with respect to the immunity of the person, etc., unless there's cooperation of the third state for waiver of the immunity.
Mr. Gunther, isn't that rather a facile response to Article 98? It would have been perfectly straightforward in Section 10 of the Act to say that no order would be made under Section 10.5 where that would require South Africa to act inconsistently with its obligations under international law, or words to that effect, following, just tracking 98 without purporting to impose any obligation on the court. If that was what it said. The complaint on the other side is that actually what is said is different, and that's what's in 10.9.
No, with respect, the scene then is set. We say that at the conventional level, this is the contemplation. This is the statute which then puts that into domestic effect. I've given a functional reason, facile or otherwise, why the South African Parliament would not replicate it in the same way as it replicates 27. But what's important then is what 10.9 is doing, because we respectfully submit that where our learned friends go wrong is where they say that there is this procedure which runs up to it from 8 through to 10. We remain, with respect, adamant in the submission that the proceeding for a competent court after arrest for purposes of surrender is exactly that which is written in the criminal or civil, doesn't matter which, jurisdiction of that court. More particularly, it says the magistrate with the jurisdiction of the area, etc. Our learned friend Mr. Trengrove said, but all you'd had to do is the magistrate does this easy little inquiry. It could have been done administratively, picking up on a point which had been put, perhaps, but it isn't. It's been put into jurisdiction. It's been put into the single court structure created by the Constitution. And furthermore, when it is said that the magistrate is just, as it were, stamping effectively, it's not so. Our learned friend submitted that the magistrate has no discretion to exercise. I think it was a proposition put to him from the bench. But if one reads 10.5, the inquiry must result in the magistrate being satisfied that the requirements of sub 1A, B, and C are met. And we submit that if we are correct, that on the day before this act coming into operation, President al-Bashir, President Obama, former President Bush, whoever, had an immunity, then the question is, did they lose the immunity by the wording of this section? And we say no, because what was intended in 10.1a, b, and c is not just some sort of administrative dog licensing check, but that in B, the person has been arrested in accordance with the procedures laid down by domestic law. It wouldn't have gone down too well in this case if they'd gone ahead, not on Magistrate Billionaire's warrants, but on the particular course they were set. But never mind that, it's in C, the rights of the person have been respected. Well, whether it's President Bush or President Putin, they would have rights under Section 12, that not to be confined in their person, not to be subjected to this particular treatment. And the question is, the magistrate would have to enter into that inquiry. The magistrate would look at this and say, am I satisfied that this is being carried out in compliance with that? And we say, the magistrate would have to say, the immunity existed yesterday. Has it gone today by operation of what I have?
What of the HSF's argument that the obligation to arrest and detain people charged with crimes against humanity exists by virtue of various constitutional provisions, and the Rome Statute simply reinforces that?
Yes.
So it's not a question of immunity being taken away from President Bush in 2002, but immunity being taken away in 1996 or maybe even 1993.
Well, what HSF has done in that regard is to move away from any contention that it is offending my vote counts and the question of subsidiarity. When you've got two statutes in place, as we're looking at it, competing over the space that we're talking about. And they say, no, we're not saying that anything is directly sourced in the Constitution. Well, we invite you to look at their papers and their heads of argument to see what they did say. But they say that if you interpret it as infused, etc., by the Constitution, then you find that's with that interpretive gloss that you are able to reach the conclusion that, as it were, primacy is given, that the wicked serving head of state, never mind the language of absolute immunity for the period, the wicked serving head of state is to be arrested and surrendered. And we respectfully say that that wasn't the purpose of the treaty. The treaty said, look, you all have your own immunities and your domestic law, international obligations. We're not going there. That it is dealt with precedingly by a statute which is not repealed, it's not amended, and it deals with a particular topic. And so we respectfully submit that the fact that you end up with a provision saying the fact that the person to be surrendered is a person contemplated in 4.2a or b does not constitute a ground for refusing to contemplate the order Well, I've argued that already by saying the one is a greater category, the other one is potentially a lesser category, depending on whether you are no longer a head of state and whether or not there's been a valid waiver. But we submit that the Helen Suzman Foundation attempt to move away from its problem on subsidiarity and simply to have resort to a notion of interpretation in vague compliance with the Constitution doesn't advance the matter any further.
Well, I just think that about the argument you're presenting on the inquiry for the magistrate.
Yes.
How does Section 10.3 of the Implementation Act affect that argument? Because 10.3 says the inquiry must be conducted as if it's a preparatory examination in terms of the Criminal Procedure Act.
Yes. Well, that's very interesting, Justice Majid, because that puts you squarely. The magistrate is not there as some surrogate administrative official. The magistrate is there just as if he or she is dealing with a preliminary step in a domestic criminal proceeding. So,
isn't that a crux of it? It's a preliminary step.
Yes, but it's within jurisdiction. It's within the civil or criminal jurisdiction of the court. Either one succeeds.
It doesn't exercise any judgment.
No, absolutely not. Well, it exercises the important...
Various requirements are met. He must issue the
Oh, absolutely, but with great respect, we know that there are any requirements are met. Some requirements are met for conviction on corruption or rape. You have to impose 15 years. So with great respect, that won't come into it. The critical thing is here is that there is a proceeding. Where is the proceeding? It's in a court. It's conducted by a magistrate. It has an important consequence which may not be imposition of a judgment or a sentence, but it results in the surrender of the person to another country. Is that anything outside 4.1 of the Immunities Act? We say no. But that I have argued. May I then sweep up on some important residual points, going to the argument of...
Sorry, Mr.
Yes,
Montfort, if I can just bring you back for a last time to 10.9. The magistrate conducts the inquiry, and he comes to the conclusion, I've got 2 warrants here, and they apply to President al-Bashir. This is President al-Bashir. What procedures have been followed in order to arrest him? These procedures have been followed. They're the right procedures.
Yes.
He's been treated perfectly respectfully and with dignity, and none of his rights under the Constitution have been respected.
Yes.
Well then, have not been respected.
Yes.
Then surely under 10.9, when you raise immunity, you're in the very situation it deals with. The fact the person to be surrendered is a person of this type does not constitute a ground. You as counsel stand up and say, yes, he is al-Bashir, yes, he has been arrested in this fashion, yes, his rights have been respected, but nonetheless, he should not be surrendered.
I think the point of difference, Justice Wallace, is I wouldn't give the last answer. I would reluctantly acknowledge the identity and 1 or 2 other factors, as you mentioned, but I would not say that his rights in those circumstances, for the meaning of 10.1c, have been respected if what he enjoyed was a right to continued liberty and to continue to exercise the offices, etc., that he has in pursuant to Section 12 and not be confined in his person. This is the difficulty. The difficulty is there is this problem of the court reconciling what was intended when there is the absolutist statement, not forever, as there's a sort of subtext of you giving impunity to everybody, but just say, well, the person's running badly or otherwise, he's running the country. He cannot be touched, or she cannot be touched. There must be some tyrants of the other gender somewhere. But that is what it's doing, and this provision is saying that when the person is to be surrendered, the fact that the person falls into the category of past or present head of state is not in itself a ground for refusing to issue the order. But I think we've been around that.
Yes, we've had your argument on this.
Now, may I then just deal with Section 5 Justice Wallace had asked me earlier, where was the claim in respect of President Bashir to immunity in this respect pleaded? And I gave an answer that I didn't think it was particularly, and I ascribed that to the circumstances, but I said it was very clear that it formed a major part of the debate. Actually, I was wrong. One finds it reasonably well specified at pages 56 to 57 in paragraphs 3.16 and 3.17, and again in that supplementary affidavit at page 105, paragraph 3.2. And the point that we want to simply make in this regard is that the contention that we cannot use the notice as against what Section 5.3 of the Act says gets precisely wrong the Kurland-Oudekraal problem. If the contention was that the minister was off her powers and didn't act in terms properly of 5.3, then that is why you attack the notice. The notice is not, as our learned friend, Mr. Unterholter, put it, subordinate. You can't use subordinate legislation in that way. This was a ministerial notice which stood and had an effect until such time as it was set aside. And we say that it is quite clear, and there's been a debate between the members of the court and our learned friends, and you've heard us on the point, it's quite clear, we respectfully submit, that in the context, a delegate could only mean people up to the head of state. One of the members of the court said, well, why doesn't it say head of state? I thought we'd try to answer that earlier and saying, because the head of state may not go, may send the deputy minister for defense or minister of foreign affairs. The point about it is that you're a delegate. The OAU did not consist of an incestuous gathering of functionaries. It was to facilitate the meeting of the heads of state. They're sent there by their country, and any other interpretation we would say is artificial. Moving on then to the question of what you've heard regarding customary in international law. I owe Justice Majid a better answer in relation to what's called Pinochet 3. In relation to Pinochet 3, the critical aspect is this. The court will remember that Senator Pinochet was caught in a clinic in London on a Spanish warrant years after he'd left office. The issue was whether or not there was jurisdiction ratione materiae. And I know that Justice Majid drew my attention to it. There is the reference in one passage to ratione personae. But what Justice Phillips was dealing with, Lord Phillips was dealing with there, was the claim that Senator Pinochet, when he was head of state, he was head of state, and you can't touch him. And as we all know, the head of the House of Lords said, no, we're not going to recognize a ratione materiae, a functionality immunity. If you as head of state mosey off to the torture chambers in the course of your duties, it's got nothing to do with being a decent head of state. And that's how essentially it was approached. But the passage you will find, and it's in the bundle, it's our bundle, volume 2 of authorities, page 175. There is one passage which refers to immunities ratione personae, and it says, where states by convention agree that their national court shall have jurisdiction on a universal basis, etc., such agreement cannot implicitly remove immunities ratione personae that exist under international law. Such immunities can only be removed by express agreement or waiver, and then it goes on to deal with the Genocide Convention. But this is in the context of dealing precisely with the fact that as regards jurisdiction ratione materiae, there is no immunity which can operate in relation to genocide. As is stated in the following paragraph, you will see it's exactly the point he goes on to make. And one can only think, if one looks at that context, because he goes on to deal with the next paragraph, ratione materiae, and as I've carefully read it, I count 7 in the next 3 paragraphs references to materiae, only the one to personae. It would seem that there is some kind of error in that what he's talking about in relation to the convention itself must have been materiae, and it wasn't dealing with personae. That was and is our reading of the matter. I must say, I haven't checked the official reports. This is the All England reports. I don't know if the official reports are any better or any different in that regard.
I say, speaking myself, it will be a startling error to make.
I'm sorry?
I must say, it will be a startling error to make because of the way he reasons it.
No, with great respect, we would suggest the contrary. Because of the way he reasons it, he can only mean materiae. And every other reference he makes in 3 pages is materiae, and he was only dealing with materiae. There was no question with Senator Pinochet, ratione personae. He was off the bench in the governmental sense. He was a sitting duck on a personae basis. The question was materiae. And that was the important thing in the case from beginning to end. It just wasn't a debate. Might I just say on the same point, our learned friends, the heads of argument for SALT, went into territory, and Justice Wallace was picking up on 1 or 2 aspects there about the position of Charles Taylor and others. With respect, Charles Taylor was out of office for 3 years. The other persons listed in the SALT heads of argument are beyond what they have in their papers that seem to have been picked up on the internet. One, Ms. Godvima, was a retired lieutenant. Another one, Jean-Paul Bemba, is a former vice president of the Congo. And there were a whole bunch of people like Maladik and others who were militia commanders. With great respect, this kind of anecdotal argument gets us nowhere. It doesn't go to proving any abnegation of the rule regarding jurisdiction, ratione personae. So, to conclude on this, the important challenge which is put out to our learned friend is one which was raised to a degree by Justice Wallace. The question is, if we are right, and if Professor Dugard is right, that the correct description, well, Professor Dugard may get more than us because we stay with O'Keefe, but that the law is poised to change. What does it tell you what a court has to conclude with great respect for the moment? It is that international customary law isn't there, and it's not saying that we are reified in 2002. What it is doing is saying that international customary law is established, as Justice Wallace was testing, by state practice. And it's not enough to say that state practice is evinced by the fact that over half of the countries in the world have signed up to the Rome Statute. It's not state practice when we live in a world where a major power, China, is receiving President Bashir as it has done, when there are indications elsewhere that others, up to, I think it's must be about 40% of countries in the world have not gone near the Rome Statute. So with great respect, it just doesn't get you there. Our learned friends for SALT should stay with the Dugard submission, poised to be, which we say means it's not there yet. And we have handed up to you what Professor O'Keefe calls the prophylactic reality dose in that regard. Lastly, in that respect, Professor Fox's article, which was handed to you, we would draw your attention to what she says in the clearest language at the foot of page 555 regarding the statutes of the various tribunals. Only provide that the official capacity of the defendant is not a defense before those bodies, and it's the same words as we have, shall not relieve such person of criminal responsibility nor mitigate punishment. This is not the same as removing immunity. And for us, Justice Lewis, if we pause there and say, that is the work of the Implementation Act. That is what Section 4 of the Implementation Act is doing. It's not removing the immunity. Immunity is done and dusted. It was dealt with 6 months before in another statute. And that is exactly why our learned friends are like moths around a candle. Do they mean that there's been a repeal? Do they mean there's been an amendment? This is their difficulty. And she goes on to say that at the top of the page, and again, if you go to the passage which they rely on at page 558, where the reliance is on the pre-trial chamber, held that customary international law creates an exception to head of state immunity when international courts seek a head of state's arrest for the commission of international crimes. Yes, that's quite right, and that is why the ICC chamber could so opine about itself. But it could not speak for you. It could not speak as to the position in this country. It did not consider what the domestic legislation here is. And what the domestic legislation here is exactly what Professor Fox has said a few pages earlier. May I then say finally on these aspects, before just dealing in a moment or two, if I may, with the amici, on the question of waiver, the attempt to rely on FIC and to equate it with the situation here, you will either find or not find that the passing by the adoption by the Security Council of its resolution constituted an accession by Sudan in the same way as in FIC, the government of Zimbabwe acceded to the SADC treaty. There's no comparison. Sudan was posted off conceptually to the ICC by the Security Council. It acceded to nothing. It did nothing voluntarily. And that is then also why the Genocide Convention does not kick in. Because the Genocide Convention is quite explicit itself when it says in Article 6, or by such international penal tribunal as may have jurisdiction with respect to those contracting parties which shall have accepted its jurisdiction. This is legal language. It didn't contemplate the gunpoint selective posting off by the ICC. And one has to stand on one's head with great respect to make it say that. And so we say, both for that reason and for the fact that the language of the domestic statute in South Africa is boringly emphatic in terms of what we would all know of Borslav versus Spangenberg and other cases on waiver, I want to see it expressly, and I want to see it in writing. To say to the Sudan, you're on trial, is not the same as saying your head of state loses his personal immunity. It doesn't address that. You could still be on trial. You could still have your generals and majors and vice presidents and even militia lieutenants on trial before there. It did not address the topic. It could not have the trumping effect to which we've been driven. May I say in conclusion, as regards the amici, we have dealt with the Helen Suzman Foundation fully in our heads of argument, and I've done so where I can in passing in the course of my argument. As regards the remaining applicants for admission, we say to the court this, that the Constitutional Court has emphasized that being admitted as an amicus is a position of privilege in the sense that the court wishes to derive assistance where it can. But it is not an entitlement of parties, even though with the distressing historical stories, such as, for instance, the ACJ and IRAI have about experiences and how they wish, as we were told, to be the voice of the people of Sudan. This court has criteria for admission as amici, and there's a great concern that in litigation like this, the whole process starts to get out of hand. And what this court, we understood to do with its rules, is to say that we welcome assistance, but we know and we can sense what happens is that amici come to reiterate and to say and to support arguments of the other parties. Hence the essentially dual criteria of this court, that it must be not novel, I've forgotten the word, different, and it must be helpful. And we respectfully submit that one always hesitates to say to well-intentioned entities coming to seek admission that they are neither. Our stance was this, that we looked at the letter and we looked at the applications and they did not make it out. Sometimes very strongly, when, for instance, it was said that we reiterate, as the ACGA did, we're content to rest, we totally associate, they said today, with the legal submissions of SALT, but we want to be in. First of all...
Well, not quite. That's unfair, Mr. Gauntlet. They say we have additional submissions to make. we bolster the arguments of the litigation
Yes.
centre.
I wrote down, Justice Lewis, the answers to your questions, and it was said by our learned friends, they were content, as you put it, because you picked it up from the documentation, to rest with the SOG submissions. They totally associate, and it's true that they then went on to raise another convention. But our respectful submission has got to be, is that an amicus has to show something which is materially different, materially helpful, if this system is going to be in any way rendered not overly burdensome and costly to the court. So we respectfully submit that the court has been in the beneficial position of receiving the material, considering it, but just like when the court does that with an amendment, the court says, well, I've seen what you want to do. I'm unpersuaded with respect to the cases made out for it. I've heard you fully. But regrettably, it does not meet these two criteria. We respectfully submit that's the answer to be given. If you disagree with us, we would still ask you to hold that we were not unreasonable when we said in response to that letter and these applications that your applications are such that we should debate them and say that you haven't met the criteria. Yes, one last point is just that, going back for a moment, if I may, to the international, customary international law, I would just ask you to consider what the DRC judgment actually held, because we heard a rather different thing in argument, we thought, on behalf of SALT. In the authorities bundle for SALT, at page 23, where it is said, we thought in the most lapidary terms, at the outset, the Chamber wishes to make clear that it is not disputed that under international law, a sitting head of state enjoys personal immunities from criminal jurisdiction and inviolability, which is the correct word, inviolability before national courts of foreign states, even when suspected of having committed one or more of the crimes that fall within the jurisdiction of the court. We respectfully submit that is why it's necessary for Professor Dugard and others to look optimistically to the future and to talk about being poised for change. If I didn't say before, Justice Lewis, we respectfully submit that wherever any cost order goes, as head-breaking a matter as this may be, according to the standards of this court, we would submit it's a matter for the costs of two counsel. Those are our submissions, and we are indebted to the court for its fortitude in this instance.
Yes, thank you, Mr. Gauntlet. The court will take time to consider both the application for leave to appeal, and if it is minded to grant it, it will give judgment on the merits. It will also take time to consider the applications for leave to intervene as amici that have not already been granted, and judgment will be handed down in that respect at the same time. Court adjourns.